Board of Governors meeting here in Spokane, Washington. My name is Hunter Abel. I serve as president of the Washington State Bar Association for 2023-2024. Is that better? All right. Serve as president of the bar for 2023-2024. We have a busy agenda today and a particularly heavy agenda item this morning with our 9 a.m. agenda matter. So let's go ahead and get right into it. Let's start with a roll call vote, a roll call from the executive director to ensure we've got quorum.
Okay, governors, when I call your name, please let me know that you are here. Francis Adewale. Sunita Angelville.
Present.
Tom Ahern.
Here.
Jordan Couch. Matthew Dresden. Okay, I thought I saw him. Okay. Kevin Fay. Todd Bloom. Nam Nguyen. Just walked in. Kari Petrasic. Mary Rathbone. Serena Sayani. Christina Larry. Brent Williams-Ruth.
Here.
Allison Whitney. We do have a quorum.
All right, thank you.
I see Bloom and Dresden they had their names up on the screens, but their voices apparently weren't coming through.
All right, thank you very much, Executive Director Nevitt. We do have a quorum. All right, thank you, Rex. How's that? Okay, we do have quorum present. Our 9 a.m. agenda item is the Council on Public Defense proposed revised standards for indigent defense and caseload limits. This is on pages 243 and 428 of the materials for the board. I have a number of individuals who have expressed interest in presenting information on this subject, including Justice Gordon McLeod, who I believe is with us by Zoom. Justice, good morning. Thank you for being here. We also have CPD Chair Jason Schwartz, OPD Executive Director Larry Jefferson, Professor Bob Berukowitz. We also have the Kitsap County elected prosecutor Chad Enright. At the conclusion of those presentations, it's my intent to allow public or member comment. Public or member comment will be limited to 3 minutes. Among the individuals who have already indicated desire to speak is former Board of Governors member Nancy Asurlis. Nancy, thank you so much for being here today. With that, Justice McLeod, may I turn it over to you?
Thank you so much. We all know we're in the middle of a public defense crisis. So many experienced public defenders are leaving the practice, and so few are coming in to take their place. In that context, we all read the national report released by the ABA and the RAND Corporation on public defender caseload standards. The results were pretty shocking. They suggested that Washington public defenders were carrying far more cases than they could do quality work on. As a direct result of that, my court decided that we needed some expert advice. So we turned to our local experts, your Council on Public Defense, and we asked them to review the report and come back to us with any recommendations that they felt were appropriate on the basis of that report. We also asked them to do something really unreasonable, and that was to speed it up as if they had nothing else to do. The CPD complied, and they have my court's deep thanks for doing so. I serve as my court's liaison to the Council on Public Defense. To be clear, I haven't voted on these particular recommendations. Nobody on my court has voted on these particular recommendations, but we really look forward to diving into them. Jason Schwartz, Chair of your Council on Public Defense and Director of the Snohomish County Office of Public Defense, is going to present their recommendations to you this morning. When you listen to Jason's report, I urge you to hear not just his own voice, but also the voices of the diverse group of stakeholders who made really difficult compromises to present something that they felt was very necessary, but also very practical. And with that, I can turn it over to Jason.
Thank you very much, Justice McLeod.
Thank you, Judge. Thank you, Hunter. Just before I keep going, I'm going to check in with Rex to make sure everybody can hear me okay. Great, thank you. And then you have the presentation for us, Rex? Yep.
As Rex is pulling that up, I want to remind everyone who's attending the meeting online that when the opportunity comes for comment, please raise your hand, and then we can make it so that you can speak.
Great. Thank you, Rex. Good morning, everybody. Thank you for being here. My name is Jason Shores. As Justice Gordon McLeod mentioned, I am the chair of your Council on Public Defense. I'm also the director of the Snohomish County Office of Public Defense. I've been a public defender now for almost 20 years, and I've done every single job in public defense that you could do: civil work, criminal work, appellate work, juvenile work, dependencies, family defense. And I'm really proud to bring that experience here to you to talk about these standards today. Next slide, please, Rex. I'm going to talk briefly about I'm going to give you a background today for the need for change, what's going on the ground in Washington. And then I'm going to spend the bulk of the time talking to you about our recommended changes, what's in the reports and the standards changes that we presented to you. And that really includes three main topic areas: support staff, attorney qualifications, and then the thing that I think is the most contentious and is going to consume the most of our time, attorney caseload maximums, followed by some comments about how we go about implementing these. Next slide, please, Rex. So just by way of background, the Council on Public Defense was created in 2004. Members of our panel include judges, criminal defense attorneys, both private and public, defense investigators, and then formerly impacted, legally impacted people who have been working with us. The CPD has in the past and is currently charged with amending and recommending indigent defense standards for public defense performance. This is the place where those standards come from and have historically come from. This body did, as you're going to hear from Professor Brukowitz at the end, did create the current standards that we have in 2010, 2011, and those are still operating. Next slide, please. Again, the long-standing guidance for agencies, for local governments, about public defense caseloads really comes from this body and the court rules. This body has in the past provided caseload maximums, has set what the qualifications are for lawyers. So for example, not any lawyer can just represent somebody on a sex offense case or a murder. So we've set those qualifications, and then we recommend provisions for support staff. Much of our work also is tied to, you're going to hear from Larry Jefferson at State OPD when I'm done, to the work that happens at State OPD. And a lot of that work is governed by the RCW. And in here, I've quoted for you a very important RCW. I think it's going to be a focus of much discussion today, which is RCW 10-101-030. And really what that says, it's highlighted there. The standards endorsed by the Bar Association for Public Defense Services should serve as the guidelines for local legislative authorities in adopting standards. These standards will help the state Office of Public Defense in the future advocate for future funding and other needs once the standards are promulgated, I believe. Next slide, please, Rex. Just by way, before we get into the details of this, I want to be really clear about what recommendations we're making and who they impact and how. So what you have in front of you is in the materials. It's Appendix A of the standards. But I want to be clear, the CPD is making recommendations today to the Board of Governors to update the Bar Association's indigent defense standards. As you may or may not know, the court has also promulgated rules for public defense standards. They're there on the right. They are largely caseloads, qualifications, and then some information about support staff, although not as extensive as our standards. As you can see on the left, the WSBA indigent defense standards are far more comprehensive. They're regulating lawyers and law firms in public defense. Historically, this has been necessary because there was no regulation and local jurisdictions were historically straddling public defenders with hundreds, if not thousands, of cases. So these standards, both the WSBA indigent defense standards and the court load standards, became necessary for regulating practice and essentially creating a caseload for the defense attorneys that would be effective for their clients. And that is the bellwether here, the Sixth Amendment, and providing enough representation to be effective for our clients. And Rex, next slide, please. How did we get to this position today? I will just share with you, the CPD Standards Committee has been working on these standards for you for over 2 years. We have consulted with practitioners, with investigators, with mitigation specialists and social workers. We've consulted with judges on our panel, practitioners from the east side of the state, from the west side, practitioners who practice in government, and people who are independent contractors. We have had some significant support throughout the process. We sent out a survey and got about 300 to 400 responses from practitioners. And really, again, the work about the caseloads was promulgated in part by the publication of the National Public Defense Workload Study in September, and the letter that you see here from the judges, which were asking, or for the justices, which were asking for this group to give them standards, and if you see it at the very end of that letter, by November 29th of 2023. We had, with this board's assistance, asked the justices for some additional time, so that's what we have today. That's why we're talking about this today. That's the background for the work that got us here, and now I'm going to move into the next slide and talk about where we are in public defense. Public defense is in a crisis right now in Washington. You've seen these articles in the paper and probably many more. These crises in public defense, you're going to hear me today talk a lot about public defenders and their caseloads, and that is real. But I don't want to lose sight of when we talk about public defense caseloads, we're talking about defendants. We are talking about people who are accused and who have a constitutional right to a lawyer. Right now, they may have a lawyer, but that lawyer is overworked, not able to spend time with them, and is effectively not a lawyer. Next slide, please. What got us here? How did we end up in this situation? As Justice Gordon MacLeod mentioned, part of the problem is that experienced public defenders are leaving the practice in droves. In a 3-month period in King County, they lost 17 attorneys, resulting in 700 transfers of cases. We call them cases because we're lawyers. Those are people. Those are 700 people who had to switch lawyers midstream. And that impacts justice, impacts the courts, impacts prosecutors, impacts victims. So the fact that attorneys are leaving should be of great concern. Part of the reason that they're leaving too is the lack of staff support. Law firms may be able to hire paralegals and legal assistants, but public defenders are dependent on our funders. And if they don't see that as necessary, public defenders don't have support staff. One of the additional concerns, and this is not unique to public defense, is there not enough lawyers? Partly not enough lawyers to come into the practice. I think that we're experiencing that. I know I see former President Clark, he's talked about that with the prosecutor's office as well. But in addition to that with public defense, there are thresholds for qualifications. And during COVID, when there were no trials, attorneys could not get qualified to represent people for the higher qualifications of cases, murders, rapes, etc. So it created this backlog, created an insufficient number of lawyers for the experience level required. Lastly, we're here at Gonzaga, the law school. The CPD was at the UW Law School last year, or maybe 6 months ago, to talk to students about recruitment. And I'll share with you the question we received the most. Tell me about work-life balance in public defense. And if you can imagine, as you're going to see some slides here, there is no such thing as work-life balance in public defense. That's not a thing. So we are not going to be able to recruit new lawyers, next slide, until we fix the problem of caseloads in public defense. What I'm showing you is a slide from April 2023 that state OPD presented. They did a survey of public defenders. They got 400 responses, current and former public defenders, asking them why they're in the practice, what would entice them to stay. And you'll see the number 2 is lower caseloads. Lower caseloads are the biggest recruitment and retention problem in public defense. Next slide, please. I want to be clear too. What we're asking today is for you to endorse the revisions to the indigent defense standards. This is not a panacea. This is not going to fix everything. As I'm sure all of you have seen many of the hundreds of letters that have come in the last however long. I've read all of them. I have a little spreadsheet. I could show them to you. One of the things that you'll see is talk about money, talk about implementation and rollout. These are all very important questions, but it starts here with the standards. We can't address funding or the rollout until we know what standards we're implementing. As I mentioned, public defense is in crisis right now. If we do nothing, we're going to remain in crisis. If we do nothing, it will be costly. It is not unprecedented that there have been lawsuits in this state about public defense. And if we don't do anything, we are going to trend toward, there already is another lawsuit, I guess, about public defense, if I'm being very candid. I think most of you know about it. The Washington State Association of Counties has sued the state for funding. But I'm talking about defendants. I'm talking about lawsuits where a defendant is sitting in a jail because they're not represented or underrepresented. And that is happening now. Next slide, please, Rex. So with that in mind, the question is, how do we fix this? How do we get more lawyers? How do we get them to stay? And how do we fund it? Again, this is just the beginning. We are the standard making body, not the funding body, not the tell the county how to run their job, or office body. So with those standards, we have come up with what I would call 4 major changes to our standards to assist us going forward. 1, we attempt to be more audience-oriented and client-centered in our language and in our application. We change the definition or expand the definition of what it means to be a fully supported attorney. I use that in quotes because that's the language in our standards. We updated the qualifications to try to address the backlog, and then most importantly, the caseloads. Next, please, Rex. I'm not going to spend a lot of time on this, but this is really important, I think, for us as lawyers. We tried to rewrite our standards to orient them to not lawyers. For all of you, I am the public defense administrator in Snohomish County. Our friend Kari here is one of the contractors that I work with to provide public defense services in my county. But that pattern is an exception. Most public defense administrators in the cities and counties are not lawyers. So in reading our standards, they do not understand them. One of the cities in my jurisdiction, the person responsible for appointing lawyers is the chief law enforcement officer. I can't imagine a bigger conflict for that person or for the public defenders, but I can imagine how that person understands our standards. So really what we're here to do is to try to update those standards and provide clarification. What we also tried to do is change what it meant to be a fully supported lawyer. 2 years ago, Mr. Jefferson, who's here, called a meeting of public defenders. We had an outstanding number of people attend a meeting, and the biggest concern was this: that public defenders do not have the support they need or the expertise they need to do their job. Public defenders are answering phone calls, making appointments, doing everything with their clients. There's not, in most jurisdictions, there's nobody in between the lawyer and the client. There's nobody writing pleadings. There's nobody sending materials other than the lawyer. As I think this group has talked about, that is very inefficient. We need to encourage funders to have efficient and cost-effective ways of providing public defense, and part of that is using our support staff. And this is the change. This is the brass tacks. Currently, our standards 4, 5, and 7 have no requirement that the agencies maintain any level of staffing for mitigation specialists or paralegals. We've added that. And the revised standards, we've changed the ratios. I'm going to be clear about what this means. There are 19 public defense agencies in the state. Kari, my friend, who's a contractor, is not an agency. She's a firm. She is a solo practitioner. We have agencies that have hundreds of lawyers, or sometimes like 20 lawyers. And these revised standards and the ratios that are here on the second bullet apply to those agencies, not to CARI. So in agencies that have more than 10 lawyers, they need one mitigation specialist or social worker for every 3 lawyers, an investigator for every 3 attorneys, etc. This will apply to 19 organizations, statewide or countywide organizations, and then I really don't know the number of cities and how they deal with their law firms or solo practitioners, so I can't really say. But these standards will impact 19 jurisdictions. For the rest, for the CARIs, we have an expert witness process by which those contractors can get these same services. Next slide, please, Rex. So we did just hit one more because it's got an animation. There you go. Thanks, Rex. I forgot there was animation here. We did a survey of we have a bunch of public defenders, and we asked them, what do you think of this support staff ratios? You can see it's broken down by paralegal in the first blocks, social workers, and investigators in the latter. And 88% and 92% of public defenders agreed with these standards. I want to focus on that second number. I know there were fewer responses, but these are responses from non-lawyers. Our survey, I think for the first time, went out to non-lawyer staff and asked them for their feedback because they're impacted by our caseloads. They're impacted by our standards. And for the first time, we've gotten staff responses, and you can see they almost unanimously agree with our revised ratios. And this impacts them the most. Next slide, please, Rex. Okay, attorney qualifications. This is an important one. I'm not going to spend a lot of time, but I want to make sure everybody can understand what's happening with these qualifications. This change in the standards that I believe will help us get attorneys qualified for murders, rapes, Class A felonies faster. There has been a bottleneck because of the inability to go to trial. And the reason that's been a bottleneck is that our current standards require trial experience before you can be qualified to represent somebody on a more serious case. So as there's been a dearth of trials, what we have is fewer attorneys getting qualified and the attorneys who are qualified becoming overworked. And those attorneys are leaving the practice. So by changing the qualification standards, I'm going to use the word relaxing. I don't want anybody to think that we feel like these are relaxed. We feel like they are stringent, but they are not necessarily trial experience related standards. Rex, next slide, please, and I'll show you what I mean. Our current standards, if I'm looking on the right where it says revised standards, where it says replace jury verdicts, our current standards, I'm just going to give you an example, speaking a little off my notes. I know I should not do that, but our current standards require something like, if you're going to represent somebody on a murder, that you have 4 jury trials to verdict. What that means practically is that if there's no trials, you can't do that. If you're practicing in juvenile court, you'll never get a jury trial because there are no jury trials in juvenile court. If you have bench trials, you will not get experience. If you are such a good lawyer that every case is dismissed in a halftime motion, you will not get qualified because you did not take your case to a jury trial. So we tried to relax those efforts. We tried to get rid of the language for jury trials, substituted it with language about extensive litigation experience. And again, since Larry's here, I want to point out we've worked with state OPD to try to replace some of the trial and litigation experience with training that I think, given some current legislation sponsored by Senator Torres and support by state OPD, they should be able to roll out in the future next year. But frankly, the training requirements, a lot of local public defender agencies and Washington Defender Association already provide a lot of the training that would be needed. Next slide, please, Rex. And again, there's no animation on this one, so this is it. This is the follow-up, the survey results from public defenders about the qualification standards. I'm going to break it down from you. Top is the felony qualification standards, misdemeanor, juvenile, family defense, and appellate. You can see there's much less consensus around these, particularly around the family defense and appellate qualifications. Regarding the family defense, I expect that is something the CPD is going to continue to work on. It's on our agenda to continue to work on those family defense standards. So you may hear more from us in the future, maybe next year or later this year about those. Same thing with appeals. But there is broad support for the changes in qualifications. And even where there's, I mean, I'll be very candid with you, a lot of public defenders do not support this because they believe trials are the only way to get experience. And I think so we're running up against some of the biases in our own field as well on this one. Next, please, Rex. All right. The party has started now. We're going to talk about caseloads. Defendants, I'm going to give you some background here. The largest revision to our standards are about the caseload standards, and these are the number of cases an attorneys can take. The changes to the caseloads, again, were prompted by the public defense workload studies and the RAND study. I want to talk to you a little bit about how they got to the information that they got to. The RAND study, when it did its work, you'll see in the subsequent slides, did a bit of a time study, a study of the time needed for cases. They consulted with experts. But to find the guide rails for what is the best public defense practice, they had to rely on, you see this third bullet down, all the things that we know of that are impacting public defenders. The RPCs, diligence, the duty to a client. If your duty to a client is such that another client's representation is impacting your representation for your first client, well, the RPCs speak about that and what we are to do. The public defenders, current public defenders, cannot do that. There is no mechanism for complying with the diligence requirements of the RPCs. But in addition to the RPCs, we have the ABA criminal justice guidelines and then the WSBA performance guidelines for criminal defense representation. These are I'm calling these the skeleton. These are the ethical and moral, I guess, legal, constitutional, I think that's all of them, duties that are weighing on public defenders that are the basis for the workload study. Next slide, please. Okay, I'm going to talk about current caseloads so we have some basis for understanding. On the left are our current caseloads. These were largely developed in the 1970s and 80s. They were codified in Washington originally by the Washington Defender Association and then by the WSBA, and then again by the court in a court rule. Now, the thing about these standards on the left is that they are numbers that are not driven by any informed or data-driven process. There was not a study like the National Public Defense Workload Study. There was not the consideration of the ABA criminal defense guidelines, which maybe weren't available in 1970 when these came out. Bottom line, these standards on the left are not evidence-based. They lack distinction between kinds of cases. So if you're looking at that 150 felonies, what that means is that Jason, who is a felony attorney, could have 150 murders or 150 stolen vehicle cases. But our current standards do not distinguish between those. I think for all of us here, we would expect that a lawyer would spend more time on a murder than a stolen vehicle case. But our standards don't make that distinction. Next slide, please, Rex. In fact, this is how it breaks down. The modern caseload standards assume that each lawyer will spend on a felony approximately 11 hours on each felony and 4 on each misdemeanor. This is every felony, regardless of case type, regardless of the number of counts. If an attorney is representing somebody on a 15-count ID theft case, and this is not uncommon, people do crime sprees, they steal purses, and they've got a lot of IDs in them. A 15-count ID theft case is common. That means you're spending less than about an hour on each count. You can't even read discovery in that time, let alone talk to your client. Our standards are causing a public defense problem. They are discordant with the workloads. Next slide, please. And if it weren't apparent by looking at it just keeps looking, sorry. Yeah. If it weren't apparent, I'm just going to share with you, I'm going to be silent for a minute and let you look at these. These were some of the written responses from our survey by public defenders and mitigation specialists, investigators. You're not going to have time to read all these. I'm going to make this PowerPoint available to all of you. Rex, next slide. Or more again. Keep going. Because there's more. 300 responses. You're good. You can go to the next one. You've got the point. Public defenders are overworked. If you read some of those, they're threatening to leave their practice. This is the conclusion that you're looking at from the National Public Defense Workload Study. Continued reliance on our current standards is misplaced in an age where defensible approaches for measuring workloads exist. Meaning, if we can assess an attorney's workload and the amount of time it takes for them to complete a case, that is the standard by which we should be measuring our work, and not a rather arbitrary 1 or 150 felony cases. Next slide, please. One sec. Okay. So how did the National Public Defense Workload Study get to where it got? The reforms that they're recommending are important in two ways. One is that they create, as I mentioned before, a case type distinction. What I mentioned before is that on our current standards, every felony is the equivalent of 1. The Public Defense Workload Study creates case types, and I'm going to illustrate it in the next slide in a moment. But how they got there is that there have been 17 different state-based studies of public defense. They're called Delphi studies. Those studies have promulgated expected hours per case type. So, for example, maybe it takes 30 hours to complete a stolen vehicle and 200 to complete a murder. Well, it tells us from talking to public defenders and experts in each of those 17 jurisdictions what the time requirement should be for each of those case types. They were then funneled through a panel of, I think, 33 experts. And with a national study, it was a cumulative work from all of those local 17 local state studies. So in light of this, the Supreme Court has asked us to review our standards. And next slide, please. All right, here is the final conclusion from the National Public Defense Workload Studies. They recommended that jurisdictions adopt case types, as you can see the case types that they've promulgated here, and assign cases based on the number of hours needed to complete those cases, which is what's on the right. As you can see, these case types and hours better distinguish between the demands of certain cases and certain clients, and also set more realistic expectation for the time needed. You'll see later in the presentation that the CPD, in adapting this to Washington, did not adopt as many case types, so we're going to just identifying that for you. And I want to be clear, I put the number of hours down in the bottom, our current hours, 11 and 4. I don't think anybody in this room and anybody on the screen, public defenders included, believe that public defenders are actually only working 4 hours on every case. They are not. I'm going to give you an example that's very personal to me, and I'm going to try to keep my voice from cracking while I say it. My wife is a public defender. She was in trial from July to November. I had 1 weekend with my wife. My wife took 4 weeks of vacation last year. That's good. That's great. She took all of CLE time. She's a volunteer for the WSBA, so she volunteers here as well. Billable hours last year. My wife did over 2,100. That's after vacation. That's not including CLEs, not including volunteer, and not including professional development time. 2,100 hours. So this bottom number on the bottom left there, attorneys are not working those hours now. The cost, a lot of the letters are about the cost of public defense. Those are real. Those jurisdictions are right to bring up the cost. But right now, the cost of public defense is being borne by my wife and by my colleagues and by Larry and his colleagues, because they're working these hours and not getting paid for it and not getting compensation for it. And it's causing massive burnout. Here's our survey responses for the public defenders. Do the National Public Defense Workload Standards better reflect their legal and ethical obligations to clients? You see there were 200 responses. Majority significantly believes that they are better reflective. We had a lot of responses from investigators, social workers, and mitigation specialists who didn't have a lot of comment about this. We also had comments from directors and and appointing authorities who thought that our current standards were pretty good. Again, these are folks who have to worry about the funding side of it, not the client in a jail crying to you side of it. People who responded to this are the collection of all of those people. Next slide, please. Okay. So the National Public Defense Workload Study did not suggest that every jurisdiction should just adopt their standards willy-nilly, and we did not do that either. They've asked for jurisdictions to modify their standards to their local jurisdiction, i.e. their state. The state laws are what's controlling. We should not ask specific counties to do this. And I'll tell you why. If we ask different counties to come up with different standards, I can guarantee you that King County will have a lower caseload standard than Asotin County. And as a result, Asotin County will have a very hard time keeping its lawyers because they will all leave for King County. So a statewide system is important for maintaining uniformity and maintaining retention so that attorneys are not leaving throughout the state. There was a defense attorney, and yeah, I'm looking at Dan, so it made me think of this, in Yakima County a year ago who left to another jurisdiction, Whatcom County, because of caseloads, and then left Whatcom County with a letter saying, I can't do any of these caseloads. So people are moving around as it is. The value of us, the collective, coming up with a standard is that it won't create that transition, and it'll create a consistent system. And ideally, I think it will allow, hopefully, state OPD or us to have some consistent numbers, data that we could share to our funders and to each other about our work so that we can better forecast future work needs as they come up. Next slide, please. Step one in mapping this to Washington and was going through every single criminal RCW and attaching with it a case type. This is kind of small. You'll see it in your materials. It's Appendix B to the standards. On the left is the case types from the National Public Defense Workload Study. The very colorful column in the center you can ignore. It's the SRA's seriousness level. And then the next column is the case weights that the CPD has associated with it. And on the fourth column is every crime. So for example, if my staff at the Snohomish County Office of Public Defense get a brand new felony DUI, they'll look at this chart, see it's a felony low, and assign that case to somebody knowing that's the charge, or that's the case type. Yeah.
Chair Schwartz, I'm going to jump in
Yes,
just
please.
momentarily here, and I don't mean to interrupt
You're
the
fine.
flow, because part of my job is to watch the clock.
Mhm.
I just want to let the board know that our next item is on at 10:30. I think we have a little bit of leeway. That's
Yep.
when we would start that. But I also note that you've got a couple of colleagues who also want to talk. And I do want to make sure we have the opportunity for members of the public as well as Mr. Enright. Thank you.
And we will. I'm almost done, just so you know. And we're okay. So part of step two of applying to Washington, because the public defense caseload study is based on attorney hours and not number of cases. We had to assess what is the recommended number of hours that we'd ask attorneys to work on their cases, not work, but devote to caseload. So we created this for you. We're assuming an attorney works 40 hours a week, 52 weeks a year. You'll see at the top, that's 80 hours. And we subtracted the state holidays, vacations, et cetera, to come up with 1,650 hours. Next slide, please. The reason that's important is it gets us to this. This is the money right here. This is the slide that we're looking for. This tells us what the new caseload standards are. At the bottom on the left, for felonies, there will be a maximum caseload of 47 cases, and they should be weighted cases. The weights are on the right. You can see them there, like a low-level felony is considered 1 credit. A murder is 7. I'm going to go through this in more detail for you in just a second, but I just wanted to show you these numbers. Next slide, please, Rex. This is the same numbers for misdemeanors. The maximum caseload is 120 cases with a weighted caseload. You can see the 2 weights there. So next slide. This is a sample caseload. I just want to get this to you. On the left, these are the categories that the CPD has adopted. On the left column, number of projected cases. I'm just going to share with you, this is a real caseload. There's an attorney who has 5 murder cases, 10 sex cases, 10 Class A's, 10 Class B's, 40 Class C felonies, and 3 clients looking at life without parole, and 3 probation violations for a total of 82 cases. That's a lot. I don't think any of you would hire a lawyer for your son or daughter who was charged with a crime if that lawyer had that caseload. When we try to figure out what does that mean under our new standards, you see the projected hours per case. That's from the workload studies. We've modified some of them, particularly in the probation area. So we multiply them, we figure out the hours needed. So again, we're working on hours now, not cases. And you see at the bottom, that would turn out to be one caseload now, this caseload would be 4 attorneys under the standards. If an attorney had not murders, not LWOPs, but it was like a low-level felony attorney, they could have 47 cases because you'll see felony low, or 41 cases, sorry. 47 cases, because that's the maximum. Sorry, I'm getting confused. If this attorney had 41 cases, again, it would be straight across. They'd only need to be 1 attorney because they're weighted the same. It's the weights that are the change and the maximum, and that's important to know. I'm gonna move on and think of the time. But does anybody have questions about this? I just want to offer that here. Okay, I'm gonna move on. Thank you. You're ahead of me. All right, we asked public defenders which standards better reflect the ethical needs of our clients, and obviously, overwhelmingly, these revised standards are what public defenders have selected. So I'm encouraging you today to support these standards, to endorse these standards, and to pass them on to the justices. And next slide. I'm almost done, you all, I promise. Keep going through this. There's some animation. I'm sorry, all. Thank you. All right, this is the implementation timeline that we are recommending. The standards that I've shown you this far passed almost unanimously from the CPD. The experts agree with 1 dissenting vote that the standards that I've showed you should be the standards. Here's our proposed implementation timeline. This is the most contentious part. I think if you saw the letters about finances and budgets, it's really implementing this. How do we do this? How do we get there? And how do we do it in a costly manner? We propose this timeline as a compromise. There are attorneys, if this timeline is implemented, attorneys in, say, King County and maybe other counties will not feel any relief until phase 3 because they're already below that, the numbers up there. And I think the concern about delayed implementation is that those attorneys will leave, and we're going to be in the cycle that we are now. There was an argument for a lengthier rollout, and the argument in favor of that was about cost, that you could spread the cost over a longer period of time. But again, that then has the counter argument about what it does to the current defenders and their retention. This is our implementation recommendation going forward. And I'm happy to answer questions at the end about that, since I'm almost done. We are not going to abandon the counties and cities. We are already, both state OPD and the National Public Defense Workload Study have created tools for forecasting FTE needs, like what I showed you on that chart, as well as managing additional attorney caseloads. So I think we are at a place where we are going to be able to help those jurisdictions moving forward. Next slide. All right. This is the focus of almost every letter from a non-lawyer, which is how much this will cost. It will cost money. It cost money in 2010 when this body adopted the current standards. In 2010, when we adopted the standards, I mean, I wasn't here, but the royal we adopted the standards, there was a lot of concern by counties that it was going to break the bank and that it wasn't sufficient. Concerned by prosecutors that it was going to overwork them. And I don't know that that has happened. I'm a public defender. I still believe the bulk of the work is happening on the back of public defenders, even though costs did increase. And I would be lying to you today if I told you that what we're proposing is not going to increase costs. It will. But it is not this body's job to fund those. It is our job to say, as professionals and experts, what are the standards in our field? And I believe we have done that. I know Larry's here. He's going to speak in a sec. He and I and the CPD will help those funders in whatever way we can. I do believe, and you'll hear from Larry, that once these standards are implemented, and not before, his organization, the State Office of Public Defense, can then talk to the legislature about funding this. If we don't do this, there's nothing to fund, nothing new. Waiting for the legislature to fund public defense in its current form without this, I'll tell you, we've been waiting for 20 some years and it hasn't changed. This will make it change. If we would like to see the state contribute to public defense, this is the best bet, in my opinion. Next slide, please. this is it. Yeah. I want you to look at these statements. I consistently struggle with upholding the best practices and responding timely to the needs of my clients due to their sheer number of cases. I hope that the RAND standards are implemented so I continue in this work and be better for my clients while not crashing and quitting. The caseload standards are inconsistent with effective assistance. Folks, we are in a crisis now. The crisis is costing the counties now. It's costing the cities now, and it's going to get worse. They're already unrepresented defendants. It's going to get worse unless we do something. These standards, once implemented, should prevent these problems. Between here and there, we've got a journey ahead of us. But when the lawyers have the time to represent clients and they're sufficiently qualified and have support staff, they can meet these challenges. And we would like to do that collectively with this group, with state OPD, with the counties. And I really encourage you today to endorse these standards. I know they're contentious. They were contentious 15 years ago. They're contentious in our own community. But this is the path forward. And I encourage you to support them. And separately, also encourage you to forward them to the state justices, to the justices for consideration as they asked us to do in their letter in October. Thank you so much, all. Larry's turn.
Thank you very much, Chair Schwartz. Very briefly.
How was this passed out of CPD? Was
Yes.
it by simple majority?
No.
Or by super majority?
Super majority, you all hear me? Super majority, there were 3 votes on the standards, 2 on the standards. Super majority passed, there was 1 dissenting vote on both those votes. So it was unanimous on both times except for 1. On the implementation, it was a friendly amendment. So it was a stand-up vote, just 1-1.
Thank you very much,
Sorry for the
Francis.
time, but I
That's-
appreciate it.
Chair Schwartz, I want to thank you for that comprehensive presentation on an important issue. Again, for the board's benefit, my plan is to try and be flexible this morning as we address this issue. And I know we have a number of members who apparently wish to comment. For time management purposes, I welcome additional proponents of the proposal, including OPD Executive Director Larry Jefferson, followed by Professor Bob Berukowitz. Gentlemen, I would ask for time management purposes that we aim to complete the proponent section of this presentation by about 10 o'clock so that we can move on to Kitsap County Prosecutor Chad Enright, followed by public and member comments. Thank you, sir.
Thank you. Again, my name's Larry Jefferson, and I'm the Director of Public Defense for the state of Washington. I'm going to grab something. This is a letter that I received, and it's from a person, and they're in custody. They're in jail. They don't believe that they're guilty. In this letter, within the first page, they've gone through 4 attorneys. They've been in jail since 2022. One of the attorneys that they were assigned to has other clients that are facing life without. And so the attorney tells that person, I don't have time to work in your case and probably can't get to it until maybe October or December of this year. And the only way that this person could get out is if they pled guilty to a crime they did not commit. Folks, the emperor has no clothes. Public defense in the state of Washington is broken. It is broken now. Our standards are fictitious that they are. I would presume that right now, every public defender in the state of Washington, not due to any fault of their own, is presumptively ineffective assistance of counsel. That means that we are we've had people go through Gonzaga Law School, any law school that they have gone through, they have taken professional responsibility. The RPCs, they are in violation of the RPCs right now because they just don't have the time to work for their clients. That's wrong. It's wrong. When that person talked about crashing that Jason referred to, what crashing is this. I can remember times in my career where one Sunday I stayed home. My family looked at me. My kids looked at me. My wife looked at me and said, "What are you doing here?" Because for that certain time in my career, I'd been at work 6, 7 days a week. A normal week for a public defender is 60 to 80 hours of work, and they're not doing a trial. So these standards represent us taking the best step forward to making sure that people get adequate assistance of counsel. Now, I can't control what the rest of society does. I can't control what a prosecutor does, and I can't control what they file. I can't tell them how to do their job. That would be disrespectful, and that would be rude. But what I can do is tell you what I can do. And what these standards do is they tell you what a public defender can do and the capacity that they have. Once you're out of that capacity, these standards help to do that. These standards help to give hope. They say that there is a horizon that is coming to where I will have an effective team. At my office, we didn't have paralegals before I got there 3 years ago. We now have paralegals. I've increased the staff from 3 support staff to 19. It's made a huge difference in the effectiveness of what we're able to do at the State Office of Public Defense. And we want it to be an example of how you practice. And so what we hope to do in the future is I don't see a future where OPD is in control of public defense for the whole state of Washington. I just think that's a mistake. Jason does a great job in Snohomish County. Anita does a great job. And there's other folks that are doing a great job. I went to Okanagan and saw their director doing drug court. She loved those people. The prosecutor loved those people. The judge loved those people. People, this is about people and about making people get the representation that they deserve, that they get the Constitution of the United States of America. That's what this is about. This is about fighting for people and their rights, and that's what we need to do. And these standards are a way to get that done. Not only so that clients like this could get something. I want to make sure that the client gets an attorney that's able to do the job. That's what we want to make happen. And we can get to the moon, and I know that we can do this together. I know I want to go to every county commissioner and say, how can I partner with you and your community? Because every community in the state of Washington is independent, is an independent community, and has different needs. And so what I want to do is work with the counties on their particular need and not give them sort of like a dictate. Although we do need these standards. So with everything in my heart, I'm asking to make sure that these standards go forward so we have a direction. And this is going to help us keep public defenders, and it's going to help us to recruit public defenders. Because you don't do public defense for money. I know higher pay is important. You need to be able to live in the house in the city where you're practicing. That's important. But you're not doing it for money. I could leave public defense today and triple my salary. Right? So doing this because we care about people. And we need public defense to have a team. There has to be investigators. There has to be social workers. Right? There has to be a team. Just like any other law office. Public defenders now should get the respect that they've always deserved. Thank you.
Director Jefferson, thank you very much. Very much appreciated. We're going to move on now to Professor Berukowitz, who I believe is online.
Thank you very much. Good morning, and thank you for the opportunity to speak with you. As Jason, I've worked with Jason as the chair of the CPD Standards Committee, and we've been working on these for about 2 years, as he said, with an incredibly dedicated and energetic group of people. And in the past few months, since the court's letter, we've been meeting basically every 2 weeks for 2 hours at a time. I have 50 years of experience now in public defense as a line defender, as director of the Defender Association in King County, as president of the Washington Defender Association, and as a law professor and director of the Defender Initiative at Seattle University School of Law. I've been an expert witness on public defense and effective assistance of counsel, and I work as the assessor of public defense services for the city of Edmonds. I first spoke to the Board of Governors about public defense standards 40 years ago when I was chair of the criminal justice section and president of WDA. Your predecessors endorsed our WDA standards then and endorsed revisions in later years. And in the past several years, you've issued statements that the CPD has asked you to issue. In 2002, with my colleagues, I made a presentation to the BOG about the crisis that we were facing then. The BOG established a blue ribbon task force that recommended standards. At the same time, the ACLU issued a report. The Seattle Times published a series on the failures of public defense, highlighting Grant County. The BOG established what became the Council on Public Defense, and we are presenting these recommendations to you today. The WSBA standards have been a model for others around the country, and the legislature by statute, as Jason mentioned, says that local governments are to be guided by them. What the BOG does here is important. I would like to emphasize several points in the letters you received. Kathleen Kyle's letter effectively outlines the changes in practice that have led to increased workload and the need to reduce defender caseload. Many of the defenders report that because of too many and increasingly difficult cases, they engage in triage. Triage is not something we can accept in law practice. It is something doctors on the battlefield in emergency situations have to do. It is not what lawyers should be doing. For each client, their case often is the most serious and important thing that has ever happened to them. And their lawyers need to engage with them appropriately, whether it is a misdemeanor theft or a homicide or a dependency case in which the state seeks to take away their child. The state senators in their letter asked for time, saying they've passed one bill that will help rural areas. What they don't say is that they rejected other bills to provide more state funding to counties, and they declined to provide the $10 million that the governor requested. I spoke to a Senate committee in December, and I recommended an urgent $12 million appropriation. The Senate has known that there was a crisis, but they took only a small step. I've reviewed carefully the letters from the counties. Overwhelmingly, they do not even mention the thousands of clients who will benefit from reduced attorney caseloads. They do not address the racial disparity that affects the criminal legal system. And most of them do not question the validity of the revised standards. Instead, they decry the state's failure to provide adequate funding and note that the state's share of funding has decreased. Some of them want you to wait and see how the lawsuit by the counties against the state comes out before you do anything. Several of the counties acknowledge the crisis, and Kitsap says their commission stands in solidarity with the CPD in the articulation of the crisis. They appreciate the work of CPD to revise the caseload standards, ensuring compliance with the Sixth Amendment regardless of geography. Clark County asks you to acknowledge the crisis, recognize the state's failure to meet its constitutional obligation, hold the state responsible, to commit to advocating for state funding, and to remain mindful that we need new programs for the entire civil and criminal legal system. That is totally consistent with the CPD recommendations. Thurston County agrees with the proposed standards, but worries about money. The Whatcom County executive believes that caseload relief is commendable, but thinks counties cannot comply. None of that means that you should vote no on the recommendations. And the letter from the King County Executive's General Counsel simply misapprehends what the Supreme Court has asked us to do and fails to recognize the court's reliance on the state bar standards. The court asked the CPD for recommendations after the new national study was released. They wanted them this past November, but have agreed to let us have until March. In the A&J decision, the Supreme Court noted that the state law requires local governments to adopt standards guided by the WSBA standards. And the court wrote this: while we do not adopt the WDA standards, we hold that they, and certainly the Bar Association standards, may be considered with other evidence concerning the effective assistance of counsel. The court has relied on the state bar, as Justice Gordon McLeod said, as the experts on this field. And it is absolutely clear that lawyer ethics are within the bar's purview. When the U.S. Supreme Court in 1972 made clear that there's a right to counsel in misdemeanor cases, there was an outcry that governments cannot meet that burden. When the CPD recommended limiting misdemeanor caseloads, there were cities in Washington that were allowing defenders to have 1,000 cases each year per lawyer. They cried out that they could not lower the numbers. Yet some cities doubled and tripled their budgets when the court issued the rule limiting cases. The standard should come first, and then we all can work to find the funding. We're asking you to revise the existing WSBA standards and send them to the court. You would not be comfortable if a loved one or a colleague were facing a serious charge that could result in loss of liberty. If you went to a lawyer and the lawyer said, "Sure, I'll work to represent your loved one, but I'll have 4 or 5 hours to work on the case." Yet that is what we expect poor people in misdemeanor cases to accept. And we expect clients charged with felonies
Professor
to accept
Berukowitz,
lawyers.
I'm going to interject. We are over time. I'm going to ask you to go ahead and bring the comments to a conclusion in order to ensure that Mr. Enright and other members have the opportunity to speak. Thank you, sir.
Thank you. I do not mean to disregard the real financial costs. We need to examine how we have allowed the criminal legal system to develop. There are scholars who write that the misdemeanor courts have been a source of discrimination against poor people of color. But one need not accept that analysis to recognize that we have used the courts to respond to homelessness, mental illness, substance abuse, and to try to regulate children's behavior. We need to invest in alternatives such as law enforcement assisted diversion, which provides help with housing and substance abuse treatment. There are still cities and counties that prosecute driving while licensed in the 3rd degree, which is basically a crime of poverty. The places that divert those cases have reduced the misdemeanor caseload by as much as a third. Not too long ago, a 13-year-old child was skateboarding on port property in Cowlitz County and was told that he could not be on port property for the rest of his life. 2 months later, he was found skateboarding and he was prosecuted and convicted of criminal trespass. When we stop using the criminal courts to respond to homelessness, mental illness, substance abuse, and teenage skateboarding, and instead help people find food, housing, substance abuse treatment, and improve education, we will not need as many public defenders. Thank you.
Professor Berukowitz, thank you very much for those comments. As an update for the board, I am going to reschedule our 10:30 agenda item to later on in the day. I want to ensure that we've got appropriate time, not only for Mr. Enright, but as well as any other individuals who wish to speak pro or con on this matter. This time, we are going to move over to Mr. Enright. Mr. Enright is the elected prosecutor for Kitsap County, and I understand also serves on the board for the Washington Association of Prosecuting Attorneys. Mr. Enright.
Thank you, and I'll try to keep my comments brief because I know you're short on time. My name is Chad Enright. I am the Kitsap County prosecutor. I'm here on behalf of WAPA, Washington Association of Prosecuting Attorneys. I know our executive director is present as well as the Pierce County prosecutor, Ms. Mary Robnett. I started my career as a public defender. I spent 4 years doing public defense, and while I appreciate these standards and the attempt to try to help public defenders, I think that these standards are tone deaf in their dismissal of the consequences. We saw some quotes earlier today from public defenders, and I guess I want to share with you some comments from public defenders in Kitsap County, and I know that these comments have been emailed to the board. These standards, quote, defy the economics of the day with respect to budget and finance and are preposterous in light of the current and foreseeable labor market. That's not a prosecutor, that's a public defender saying this. Public defender saying these standards are shockingly unrealistic and will ultimately do more harm than good as we descend into chaos, attempting to fulfill them while law enforcement continues to arrest and prosecutors continue to prosecute. So I don't know that while there may be some significant support from practitioners, that should not be considered universal support. The consequences, whether intended or unintended, are going to be devastating. We start with a known attorney shortage in the state of Washington, prosecutors and defense attorneys. There is a known attorney shortage. So to suggest that an attorney shortage is an unintended consequence, I think that that is being generous with language. We know that that will be the consequence because that's where we are right now. For the last 15 years, we've seen the number of law school graduates go down, fewer and fewer. The reality of this proposal is that in Kitsap County, we currently have a public defense office that employs approximately 20 people. That's attorneys and staff. Their estimate is that they would have to hire, conservatively, 67 more attorneys, staff, investigators, social workers, mitigation specialists in order to meet these standards. Kitsap County does not have the resources or even the physical space to bring in those 68, 67 more people. We don't have the space. We don't have the structures. We don't have the security. We don't have the facilities. Some of these standards are, frankly, comical. An experienced supervising public defender, and as a supervisor, they would be taking on less cases. From what I've seen here, what I've been told from our Office of Public Defense, that attorney would be limited to 23 and a half cases a year. Now, the way the cases are weighted, he could do 2 murders and 2 sex cases, a total of 4 cases for an entire year under these standards. When I did public defense, maybe I was not the greatest public defender out there, but 4 cases in a year seems awfully low. In most counties, nearly everyone qualifies for public defense. And I think what we would see is the realistic possibility here is that counties are going to be more restrictive in terms of who qualifies for public defense and really examining whether we should be giving public defenders to nearly every defendant, as many counties do right now. But what I'm really concerned about is access to justice. When we look at this, I've heard 2 theories from my friends in public defense. Their theory is that this proposal is designed to create chaos. That they know that there is no realistic possibility that counties are going to be able to meet these standards. And the only realistic way these standards will be met is by creating a state agency. If we want to create a state agency, let's have a discussion about creating a state agency. But let's not create chaos. Let's not create an emergency. Let's not create a crisis in order to create that state agency. The other theory is that this is really going to limit the amount of cases that prosecutors can bring. In Kitsap County last year, we dismissed 100 misdemeanor cases, not because they were bad cases, not because we thought that they were cases that shouldn't have been brought. They were dismissed because we didn't have a public defender who could take on those cases. And that's why we dismissed those cases. And by taking an economic situation here where we already have a shortage of attorneys, creating an even greater shortage, frankly, there are going to be a lot of cases that we're not going to charge. I know Professor Berkowitz said that lawyers should not have to triage cases. I triage cases every day. There are cases that I don't charge because we don't have the attorneys, and there will be cases that we don't charge because we don't have the public defenders. If there are cases, if there are charges, if there are crimes that we should be decriminalizing, then let's have that conversation. Let's let the legislature decide it. But let's not create a crisis and force a prosecutor's hand, say, look, prosecutor, you have a choice. You can either file charges against a defendant who has no attorney, potentially violating their constitutional rights, or don't file charges at all. That's not what victims expect of us. We have to prioritize our cases every day, and that's what we do. All in all, I appreciate these standards. I understand the importance of these standards. I know that public defense is hard. I know what it's like to not have caseload limits. I know what it's like to be asked to take on more and more cases. I know what it's like to have multiple murder cases and a handful of sex offenses and a drawer full of domestic violence cases. I know how hard it is to meet the RPC requirements that I act with diligence. I know what it's like to have my cases pile up. I know what that's like because I'm a prosecutor, and that happens to us. And I don't believe that should happen to defense attorneys. It's what the state bar expects of prosecutors. It's what the state bar expects of prosecutors, and what the Supreme Court expects of prosecutors. It's what the public expects of us as public servants. That's not how we should treat public defenders. But it is also not how we should treat victims of crime. And by creating a crisis, by taking a shortage and making that shortage even worse, we will not be able to charge a lot of crimes. And those victims of crime that are already relying on overworked prosecutors taking on more and more cases, they're not going to get justice. So I appreciate the intent of these standards. I'm not sure how realistic they are, and the impact on counties and local governments is significant. There's just simply no way, I think, in Kitsap County we would be able to meet these standards. It will create a crisis. It will create more of a shortage. It will create more situations where people are left unrepresented. That is not anything that I would support. So I am asking that you not approve these standards.
All right, thank you very much, Mr. Enright. In a few moments, we're going to move on to member and public comment. Before doing so, I want to invite the board members' attention to the series of written comments we've received over the course of the last several days. I believe they're all in box. They include, from my notes, comments from, I believe, dozens of practitioners. We've also received comments from officials in King County, Franklin County, and a letter from a number of state legislators. So again, invite the board members' attention or re-attention to those letters. If I have missed any category of letters, I apologize. It's just based on my own informal notes. At this time, we are going to move on to member and public comment. The first individual who I have written down for this purpose is one of our former board members, Nancy Surlis. Before either having Nancy come on down, maybe to the presenter's spot there, one thing I would say for all of our member and public who desire to speak is that if you do desire to speak and you are online, please raise your hand. I see a number of individuals have already done so. I'm going to try and limit member of public comment to 3 minutes. Depending on the number of requests we have for people to speak, I may end up needing to reduce that even further to 2 minutes in order for the board to have a full and appropriate amount of time to discuss this important issue. With that, I'm going to turn it over to Nancy.
Oh, sorry. I don't have my glasses on, so I couldn't see. Good morning, everyone. Welcome to Spokane, Nancy Isserlis. I want to say, first of all, I'm making these comments as a civilian, bar number 11623, class of 80, Gonzaga Law School. I am the chair of the Washington State Public Disclosure Commission. There are a number of elected officials that are on this meeting today, and I just want to make it very clear that I'm not making these comments in that capacity, but simply as a member of your organization. Steve Crossland joined us from Kashmir this morning, and he and I served on the Board of Governors when this issue first came up, I think 14 years ago. And this is like a dream that I had before when I heard almost exactly the same comments that Steve and I heard when this issue was first raised, when our Board of Governors passed a proposed rule on the Supreme Court on this. And my dear friend Bill Hislop at the time, who's no longer with us, he died a year ago, who was a member of this board and a former president of this organization, at that time chaired the Council on Public Defense. If you know Bill, he was a two-time appointee as federal prosecutor in the Eastern District of Washington under Republican presidents. So he was no public defender, I can guarantee you. So I just want to read, I found this last night, and I'm going to read a paragraph from the eulogy that I gave at his funeral last September. I was on the WSBA BOG when Bill Hislop chaired the Council on Public Defense, which led a years-long study of caseloads for public defenders. It was highly controversial, as it is today, and I witnessed meeting after meeting when Bill took public input from many people who were diametrically opposed to the idea. He listened, he learned, studied, and never wavered. And this was, I think he was the chair of that for almost 2 years. I know he took a ton of personal hate letters that he got from people for making the recommendation that was ultimately made to the Supreme Court, which resulted in the caseload standards that we have today. It was a bold move for the board at the time. It was a bold move for Bill to recommend that to this board. And I just felt, the call to come and to channel him a bit this morning. So I hope that you will take those comments into consideration as you make your vote. Thank you.
Thank you so much, Nancy. Very much appreciate that. At this time, my intent is to move on to member and public comment. We have a variety of hands raised online, but before doing so, I see that our own Governor Tom Ahern has his hand raised. Tom, is this a question, comment, or observation that's appropriate this time, or do you want to save it for later on during Governor discussion?
I will admit, I do want to comment on this, but I don't know if that's later at our discussion or not. So I will do what you tell me to do. Speak now or later.
I like Tom's approach on this. Tom, may I ask a favor? We have a large number of folks with hands raised. If you're able to hold on to those comments, I'll ensure that all the governors have plenty of time to discuss this issue.
That's great. Now I have to try to figure out how to take my hand down. Thanks.
All right. Thank you very much, Tom. So at this time, we are going to move on to member and public comment. I see a number of hands raised. I'm just going to go in the order in which I've received them. As an advance heads up for our member and public who may wish to speak, the order I have is Sean Sant, Adam Heyman, David Montes, Michael Schuler, Molly Gilbert, Eric Johnson, Anita Kendallwall, Theodore Hastings, and Colin Bradshaw. Each of you are invited to speak for 3 minutes, and we'll start with Sean Sant. Sean.
Thank you, members of the board. I don't know if I need to activate the camera. I tried to do that on my end, and it doesn't seem like I have that option, so.
I'm told it's just audio, and that's fine. We can hear you perfectly well.
Perfect. Thank you. I'll try to be short. I too, like Chad, I'm an elected prosecutor for Franklin County, and I was previously a public defender and really enjoyed that role and the opportunity that we have to serve members of the public. I've represented individuals accused of from everything from murder to DUI. I recognize and appreciate the opportunity to revise or at least reconsider this weighted system for case equivalence. I think it's important to look at a qualitative approach, not just numbers. When I first saw the numbers come out, I was surprised because according to that number, it seems like, well, I could take 100 murder trials and that would be within those standards. So clearly there has to be a recognition for a weighted system to give a qualitative approach. I also want to address the issue that I also feel it's important to give weight for the experienced defenders. We've had several public defenders previously prior to the original release of caseload limits. And some of those longtime defenders got out of it because of that change. They were some of the more experienced attorneys, and they could do and effectively represent individuals without giving any kind of credit to their experience and expertise. These standards seem to paint a broad brush from those immediately graduating law school all the way to those that have been in the practice 30 to 40 years. And I think that has to be taken under account to make sure that we are, in fact, giving credit for those individuals that can spot those issues, be able to dedicate the necessary time and expertise on a case. And I don't think that these caseload proposals do that. The other concern that I have more pointedly is hearing and reflecting upon the concerns raised by our public defense manager. The issues that were raised are that we have been in a challenged position trying to locate and find qualified defenders to take on cases. These are individuals that take on a small number of cases. They've had to break it out, not looking for people to take the maximum, but simply trying to contract with attorneys to take 25, 50, or other similar caseloads just to get them to take any kind of cases that are available. And one of the struggles that Chad had indicated is that you just simply do not have available attorneys that are in the market, in this current labor market, that are willing and able to take on those cases. So I just ask the board to consider the fact that adding these kind of caseloads right now with the current labor market, it's really impossible. I almost looked at, after hearing some of the comments today and looking at the report, it seems like we almost need to consider a reversal of the priorities, maybe adding the support staff to offices of public defense. That actually might be of more benefit and actually a more feasible task that we could meet in the near future by being able to add additional support staff to give public defenders
That's time.
that additional lift. And I think that would be something worth
Mr.
considering.
Sand,
Thank you
Mr.
very
Sand,
much.
I'm going to interject. We are at 3 minutes. Thank you very much, sir.
Oh, thank you.
Thank you. All right, we'll move on to Adam Heyman. After Adam Heyman will be David Montes. Thank you.
Thank you, everybody. My name is Adam Heyman, and for the past 20 years, I've been a public defender both in New York City at the Legal Aid Society and also here in Seattle, Washington. I've dedicated my heart and soul to fighting for people accused of serious crimes, and it's an honor to be here today to speak to you at this watershed moment. From my perspective, going into the jails every day and looking at people in their eyes, I struggle with telling them that they have to wait years and years to get their day in court. I'm horrified that in 2024, in our democracy, in this state, people wait before they get their constitutional rights. If we believe in a speedy trial, if we believe in a presumption of innocence, we should all care to make these changes as soon as possible. I can tell you without a shadow of a doubt that my clients sit in jail and rot and wait, many of whom are overcharged and some of whom are actually innocent. Change these standards. It's not going to happen quickly, but we need to do something about this. I care so much to make sure that my clients' constitutional rights are defended every single day. I cannot continue to stand by and watch as our clients suffer, as their families suffer, as our community suffers. Please do this. I can tell you that even with 8 murder cases in a year, I will still struggle to give every person what they are entitled to, which is a zealous advocate. My last murder trial was almost 50 witnesses, 10 experts, over 10,000 pages of discovery. I struggled to do what he was entitled to do with a very righteous self-defense claim. I appreciate all of the complications of this, but there's one thing that I know clearer than anything else, that you have a right to a zealous advocate. You are presumed innocent, and you have a right to a speedy trial. These do not currently exist in the state of Washington. Thank you very much.
Thank you, sir. We'll move on to David Montes, followed by Michael Schuler.
Thank you. My name is David Montes. I'm here on behalf of the ACLU of Washington. The ACLU of Washington has sued public defense systems in at least 3 counties, and we've seen the damage that inadequate public defense can do to people's lives. But I think more importantly for me, it's personal. I am one of the attorneys that Justice McLeod was talking about, that Jason Schwarz was talking about, that Bob Berukowitz was talking about. I left public defense after 12 years in December of this year and joined the ACLU. In my last year as a public defender, I did 4 murder trials. I did 2 other Class A trials. And when I was done with those, I still had 6 murder trials. When Jason said that there are people who are talking to their clients about when they might have a chance to do their case, this is absolutely true. I was one of those attorneys telling someone charged with murder that it would be a year before I had a chance to reasonably look at their case and give attention to that. Jason talked about experienced public defenders leaving. I had a client along with another attorney who signed the ACLU letter to the Board of Governors who represented a client who was arrested in 2018. He had 3 attorneys before me, all of whom left public defense because they could not handle what was happening. 4 years after he was arrested, we represented him, and he was found not guilty. He waited 4 years. And that is directly attributable to the current standards that allowed me to have 6, 7 murders at a time. With respect to Mr. Enright, who said this is to sow chaos, to create a crisis, there is a crisis. There is chaos. There are people sitting in our jails waiting in our communities with this disrupting their lives. The responsibility of the WSBA is to set minimum standards for attorneys. We have a study that says what the minimum standards are for attorneys using a rigorous process. You need to adopt that study. It's undoubtedly going to create problems, but the problem that exists right now is far bigger than those problems, and this is the first step, and I'm asking you to take it on behalf of my clients and the ACLU of Washington. Thank you.
Thank you, sir. We'll move on to Michael Schuler, followed by Molly Gilbert.
Good morning, everyone. I just want to make sure you can hear me if my microphone's working. Excellent, seeing heads nod. Thank you for taking the time today. My name is Michael Schuler. I'm a King County Public Defender. I'm a current misdemeanor attorney supervisor. And prior to that role, I was a felony trial attorney and will be returning to that role shortly. I've practiced here for 10 years. I want to start by addressing briefly the comments from the prosecutor from Kitsap County. I think we have a chicken and egg problem here. I recognize that there is a shortage of attorneys, but I think that shortage of attorneys is in part due to the fact that this work is impossible. These caseloads are crippling. It is an impossible task to sit down with a client and tell them that I can't work on your case effectively quickly. And if we don't pass these, it's going to get worse because people are leaving and people will continue to leave. Like Mr. Jefferson said, there are jobs that have a lot less work and a lot higher pay that are very available to former public defenders. I want to talk about a personal story from one of my cases. It's another tale of a homicide case that took far too long to get to a resolution. My client was charged in 2017 with a murder he did not commit. He was held on bail that he could not afford for 5 years. Our trial lasted 4 months, and at the end of it, the jury acquitted him. The reason it took us 5 years to get him a not guilty, this man lost the entirety of his mid-20s in custody for a crime he didn't commit, is because of these standards. In the time I represented him, I tried a number of serious Class A cases. The average length of those trials was 6 weeks in length, where it would be virtually impossible to do additional work as I was working upwards of 70 to 80 hours per week on those cases. I carried a heavy caseload of third strike clients who would take over a year to get their cases worked up to a point where they could be effectively resolved. I handled numerous sex offenses of clients who, again, I did not have the capacity to work on. My story is not unique. This is the story of every public defender across this state. Every single person is having to triage their cases, which is an impossible position to sit in. You all have the ability to fix that. These caseload standards would still mean that we'd be working long hours and hard hours, but it would mean that our clients who are chronically underserved, disproportionately Black and brown, all of them poor and impoverished members of our community, would actually have someone who could sit down, work their cases, and move things quicker. I wish my client who sat in jail for 5 years had an attorney who could get that case ready for trial in a year or two. It still is a long time, but that is a more realistic time to work up these monstrous, massive cases with dozens of witnesses, tens of thousands of pages of discovery. If I had that time, I think my client would have had his 20s in the community where he was absolutely supposed to be because he was not guilty. This is a hard decision. I recognize it's going to be fraught with issues, whichever way you go on this. But I hope we all can do something today to help our Black and brown and poor members of our community who are stuck in the criminal legal system. We all talk about caring about racial justice. This is an opportunity to put your money where your mouth is on that. And I appreciate you for your bravery on this, and I thank you for your time.
Thank you, Mr. Schuler. We'll proceed on to Molly Gilbert, followed by Eric Johnson.
Hi, my name is Molly Gilbert, and I am the union president for all line attorneys and staff employed with the King County Department of Public Defense. I am also a member of your own Council on Public Defense. When my jurisdiction invests in criminal justice improvements, the impact on public defense is rarely part of those discussions. For example, when Seattle funded body cameras for the Seattle police officers and King County funded body cameras for King County sheriff deputies, no thought was given to the effect on public defense. The fact that every police response now includes hours of body camera footage with no increase in public defense budget. It is politically advantageous in every jurisdiction to ensure that advances in police investigations, forensic testing, and technological evidence are adopted swiftly. But every one of those advancements, every investment that is made in law enforcement, in prosecutors, or in the courts themselves is rarely accompanied by a comparable investment in public defense. And this has gone on for decades. The first case that I ever worked on in 2009 was assisting a defendant facing the death penalty for the murder of 2 family members. The entire case file, all of the evidence collected by the detectives fit on 2 CD-ROMs. And today, 15 years later, I'm assigned to felony cases that have over 100 gigabytes of police evidence, with hours of body camera footage, cell phone extractions, GPS location data, and multiple forensic reports. Technological progress by law enforcement and prosecutors has been, for public defense, a slow and quiet death by 1,000 cuts. Every single oppositional view that you've heard today offered no solutions, not a one. All of them point to budget constraints that they don't want to deal with, or suggested that ethical defense of our impoverished clients will somehow inhibit prosecutors upstream from us. We need your help as the Board of Governors to ensure that every person who may be charged in any Kitsap County prosecutor's desk drawer is provided appropriate representation. Public defense, its body of work, and its practitioners are anathema to politicians. That is quite literally why these standards exist. So please approve the revised standards. Thank you.
Thank you very much, Ms. Gilbert. We'll proceed on to Eric Johnson.
Good morning. I'm Eric Johnson. I'm Executive Director for the Washington State Association of Counties. Mr. President, members of the Board of Governors, thank you for the opportunity to speak this morning on the proposed revised standards for indigent defense and caseload limits, and certainly the crisis that we are facing. My comments are intended to highlight and complement the letter that we submitted and those of the many counties across the state of Washington. I am sure that you are by now aware of the fact that counties fund 97% of the costs associated with the trial court indigent defense system. One thing that should be clear to all of us, and it's highlighted in multiple studies throughout the past 3 decades, is the absence of a state partner in funding their public defense system, the one that they are constitutionally responsible for. I want to acknowledge the vast amount of work and certainly the presentation that Jason did this morning on the revised standards. Our focus is not on the technical specifics or the merits of the proposal. You've heard about many of those, but rather on the consequential implications of the proposal that we'll have on counties. We just have to recognize that we are challenged right now to administer and fund the existing system, let alone to implement the proposed standards. Currently, we spend $200 million a year on public defense services. We get $5.8 million from the state. Conservatively, the proposed amendments will cost us an upwards of $600 million when ultimately implemented through the phased-in system. This is untenable for virtually every county in the state. We, in our letter, really asked you to contemplate a number of issues as you adopt the proposed indigent defense caseload standards. We ask you to really seriously consider them, and I won't repeat the things that we put in there, but it was the heart of it was to join us to advocate for state funding to support the complex and intertwined system of behavioral health, criminal and civil justice system, the judiciary, and public defense services, and to assure the integrity and fiscal stability of the entire system. As I reflect on my 25 years dealing with this issue, I want to close with something that then King County Superior Court Judge Deborah Fleck said when I was a young county commissioner sitting at a round table talking about the Justice in Jeopardy initiative. And it's always stuck with me that Washington State ranks 51st at the time behind Puerto Rico in state revenue to fund the state's trial court system. And unfortunately, I think that probably is still a true statement. Thank you.
Thank you very much, Mr. Johnson. We'll proceed to Anita Khandelwal, followed by Theodore Hastings.
Thank you. My name is Anita Khandelwal. I am the King County Public Defender. I'll keep my comments brief. First, I want to ask the BOG to act with urgency. The proposed standards will ensure effective representation. They reflect the complexity of public defense practice in an age of body-worn cameras and other forensic technologies. The status quo is not tenable for our clients who are disproportionately BIPOC, nor is it tenable for our staff, as you've heard. Second, public defense clients do not have a choice of lawyers. Those who can afford attorneys do not need this board to adopt caseload standards of any type. They can simply pay for the services that are necessary. Our clients, however, need you. They need your protection. They need you to adopt caseload standards. They need you to do this to ensure that they get representation. And finally, I want to highlight that the CPD proposal, and I am a voting member of the CPD, has a multi-year phase-in, and this is precisely so that counties and local jurisdictions have the time to make the necessary budgetary adjustments and to find the necessary staffing. I urge you to act with urgency and to support these standards. Thank you.
Thank you very much, Ms. Khandelwal. On to Theodore Hastings, followed by Colin Bradshaw.
Thank you for the opportunity to speak. I am a King County Public Defender and member of SEIU 925. I wholeheartedly agree with what my colleagues and fellow attorneys have said as far as the impact of the current caseload standards on us as public defenders as well as on our clients, and I join in that, but I'm not going to belabor that point. What I wanted to say is similar to what Mr. Montez had articulated in response to Mr. Enright. We are in a crisis now. Our justice system is in a crisis now. And the question is, what are we going to do about it? Or are we going to do anything about it? And Mr. Enright noted that, one of his primary concerns, and I think everybody's primary concern really should be getting justice for victims of crime. And although I'm now a public defender and I defend people accused of crime, I've also been a victim of crime in my life. And so I know a little bit about what it's like to be a victim and how that feels. And I would submit that someone finding themselves in a situation where their case is not resolved for 2, 3, 4, 5 years because of backlogs in the justice system, that's not justice for a victim. Justice delayed is justice denied. And additionally, since the advent of DNA technology and the work of the Innocence Project has found that a large contributor or often a factor in a wrongful conviction is inadequate defense. Imagine being in a position where you're a victim of a very serious crime and come to find out 10, 20 years later, the person that was put in jail is not the person that victimized you. The person that victimized you is actually still on the street and has been that entire time because the defense attorney assigned to the person accused didn't have the capacity to look deep into the case and find out whether the right person was accused. So this is a crisis not just for public defenders like myself, not just for my clients, but this is a crisis for our entire justice system and everyone involved in it. And I understand that there are concerns about where we're going to get funding to implement these standards. Those are valid concerns. Those are important concerns. But the question here is, are we going to accept a system of justice in a crisis state, or are we going to start on a path of doing what it takes to make sure that in the state of Washington, we provide justice for everyone involved? Thank you.
Thank you very much, Mr. Hastings. We'll proceed on to Colin Bradshaw, followed by Mr. Dow, who's here in the room.
Thank you. Good morning. I appreciate the chance to speak. I'm a young public defender in King County in my 3rd year of practice. I came here from Oregon where I carried a mixed felony and misdemeanor caseload. I just want to give you some numbers to think about regarding my workload. I'm in the civil commitment unit. I've been assigned 231 cases since I started on June 12th. The state case cap for civil commitments is 250. I have 19 cases left until I hit my yearly cap, and I'm less than 9 months into the job. I will have maxed out for the entire year in 9 months. I often begin my workday around 6 p.m. I start my days much earlier when I have to prep 1 or 2 or 3 hearings set for that day. I work full days. I rarely take lunch. I work weekends not infrequently. I absolutely struggle to give each of my clients the representation they deserve. It has been made abundantly clear to me by folks who have been around for longer than I that my unit, the involuntary treatment unit, is considered a break rotation. It is where felony attorneys who are burnt out get rotated so they don't quit. My workload is as good as it gets for caseload attorneys in King County. I am worried to transfer into the criminal practice because I know that the criminal caseloads are significantly more demanding. I am in the stage of my life where my wife and I are talking about starting a family. I am deeply concerned that my life aspirations will be limited by the demands of my job. Concerns like mine are precisely the reason for this labor shortage that multiple commenters have discussed today. I already know I will never be able to buy a house in Seattle because of my career decision. My wife and I have accepted that, but we will not let our life dreams be limited by impossible caseloads here in Washington. Nothing short of adopting these caseloads is going to fix the state's ability to hire and retain lawyers. Nothing short of adopting these caseloads is going to allow our clients the kind of representation they are guaranteed under the Sixth Amendment. Nothing short of adopting these caseloads is going to fix public defense. Thank you.
Thank you very much, Mr. Bradshaw. At this time, we'll proceed to Mr. Dow. We invite you to come down to the presenter table.
Good morning. My name's Charlie Dow. I'm privileged to say I'm a dedicated public servant, embattled public defense attorney, and exhausted public defense manager for Benton County. Frankly, I carry felony caseloads in 2 counties. I am a part of the problem, and I am also a solution. I am an attorney that got that 5th case. I am the 5th attorney. I am also an attorney that has had to pass on that case. It doesn't feel good. The caseload standards as proposed, if you ask me if that's where I want my practice to be at, the answer is absolutely yes. If you ask me if I believe that that's possible in Benton County, the answer is no, not yet. Running the numbers for our historic case filings and dividing it by just the basic, like assume every felony is 1 point, I would need 83 attorneys to cover our commitments in district court and felony and superior court, not including juveniles. A quick search, I believe our county put this statistic in our letter, but we have 89 attorneys listed as active, eligible to practice, and listing criminal as part of their practice area in Benton County. So I would need to hire 83 of those 89. That means I would need. I was at a meeting with my judges in Superior Court, and talking about these caseloads, and they genuinely asked me, "What can we do to support you?" And they laughed when my honest answer was, "I need you all to quit and apply. I need to hire the entire prosecutor's office." I understand, and I've read the Rand report, and I hear the comments, and I live those comments. I see what it is to not return a client call. But there are impacts here that I want to bring the board's attention to. We are talking about a standard, and we're talking about it solely in the public defense, realm. I exist in an ecosystem that also exists with private counsel, even if those counsels don't take public defense cases. What the board has before it is essentially a statement, if adopted by the board, an expert statement on what the hard deck is for constitutional effective assistance of counsel. Now, those private attorneys may not be, bound by this public defense rule, but they are going to take notice. And right now, the divide between those that qualify for our services and those that don't and can't afford an attorney is pretty close. It's not a big canyon. But if a private defense attorney sees that they may be held liable,
Mr. Dow, that is time.
can I just finalize the 1 point?
Please bring it to conclusion. Yes,
If
sir.
that private attorney sees that they may be held liable for taking more than 47 felony case points, they have to reduce their caseload. That means their rate is going to go up. That means my opportunity costs for contractors who come to us for a stable income now goes up. And the risk of going out on their own and getting those high dollar cases becomes more profitable. So not only are we talking about full-time equivalents, we're
Mr.
talking
McDowell,
about
I
raising
have to cut you
contract
off,
rates.
and thank you, sir. Thank you very much for coming here today. And I do want to thank all of the members and the public who provided comment, both here in person as well as online. I want to provide one more opportunity if we have any individuals either here in the room or online to provide public comment. Looking here in the room, I see none in the room. Looking online, I do see Sam Suoka. Sam, I apologize if I've mispronounced your last name, followed by Shannon. We'll move on to Sam, followed by Shannon. 3 minutes apiece. Thank you.
Thank you, and you pronounced it close enough. It's Sueoka. My name is Sam Sueoka. I'm a recent law school graduate from Seattle University. I'm a public defender with DPD. I do misdemeanors in Kent District Court. I'm also a member of SEIU 925. Our struggle and our client struggles are not comical. My dream has been to help people. It's the very reason I decided to become a public defender. However, without adequate resources and with a shortage of line attorneys, I oftentimes feel as if I'm not helping my clients. Oftentimes my coworkers and I feel like cogs in the machine, just a necessary piece in the incarceration system, which cuts against the very reasons public defenders exist. Without resources, we cannot prepare for trial or motions as well as we should be able to, and instead we serve as a placeholder, just a symbolic check mark to say that this person was represented by counsel, so everything was fair. We are exhausted, tired, and overwhelmed. Having public defenders that way is not due process. It is not effective assistance of counsel. We need relief, and these caseload standards will help provide us with that. All of these constitutional safeguards protect all of you on this call, but it is meaningless if the very agent, public defenders, who are entrusted to hold courts and prosecutors accountable lack the capacity and resources to do so. I've had long conversations with my colleagues about burnout, and in reality, we do not know how long we will last. And I'm a new public defender. I've only been doing it for less than 2 years. We've talked very seriously about leaving our jobs as recently as this week, and it is a constant and ongoing conversation. As lawyers, we want to be able to be proud of the work that we do, but with our caseloads, we cannot do that. I joined with a class of around 15 new dedicated attorneys, and since then we've decreased substantially. My young class of attorneys, we are the future of public defense in King County, and without these changes in caseload standards, you will not have new attorneys coming into the felony unit. The Kitsap prosecutor complained about a shortage of lawyers, but not passing these caseload standards will only increase that shortage. Thank you.
Thank you, sir. We'll move on to Shannon.
Good morning. My name is Shannon Kelly. I'm a mitigation specialist in King County, and strongly urging you to pass these new caseload standards. As far as I'm aware right now, there are no caseload standards for mitigation specialists. Passing these standards will ensure or provide a ratio for mitigation specialists and hopefully increase our numbers. Mitigation specialists are often the people picking up the phones when attorneys don't, listening to clients talk about how they've been wearing the same pair of underwear in custody for 2 weeks, or learning that a client who's in custody, whose brother's on their deathbed, trying to figure out how we can get a temporary release so they can see their brother before he passes. This work is impossible. It is emotionally draining. And when you are trying to support 60 to 70 clients in their life, in the worst time of their life, with 7 other colleagues for hundreds of people, it's exhausting. I don't know how much longer any of us can do this without further support. So strongly urging y'all to pass these caseload standards. Thank you.
Thank you very much. At this time, I'm going to ask if any other final member or public comment. Looking here in the room, not seeing any. Looking online, not seeing any either. So for purposes of time management, as the board is aware, I'm going to reschedule and have rescheduled our 10:30 agenda item. I am looking at doing the same for the 11:30. I'm also aware that we've been going about 2 hours, and I'm also aware of the demands of our time on our staff. So we're going to take a brief 5-minute recess. We'll come back. We'll engage in board member discussion. Thank you. All right, everyone, welcome back. We are going to go ahead and get started again. This is continuing our Washington State Bar Association Board of Governors meeting, continuing the 9 a.m. discussion on the Council on Public Defense proposed revised standards for indigent defense and caseload limits. Again, I want to thank the members and the public who provided comments on this issue, as well as the presenters, both pro and con. At this time, we're going to move into board discussion. Earlier, our own board member, Tom, had his hand raised. I asked him to hold off the comments until we arrived at this point in the discussion. It's going to turn it over to Tom.
Okay, I'll try to be quasi brief. To me, the question here is, are we going to walk our talk? We talk a lot about constitutional rights, which includes the constitutional right of criminal defendants under the Sixth Amendment, Gideon v. Wainwright, et cetera. But we as a state are failing. I mean, our approach is we set up a bunch of underfunded and understaffed MASH tents on the criminal justice battlefield. We talk a lot about equity. And to me, equity includes equity between the haves and the have-nots. And when it comes to criminal defendants in our have-nots class, we put them in a situation that none of us would want our daughter or son or other family member to be in. You know, we talk about attorney wellness, which, okay, that's a touchy-feely term I really don't like. But the emails and the letters have confirmed that we put public defenders in a horribly unhealthy situation that none of us would want our son or daughter or family member to be in. So if we actually mean what we say about criminal justice and equity and attorney wellness, I think we have to approve this. And I realize it's expensive. But, you know, way back in the Brown v. Board of Education days, there were school districts across the country, not just the Deep South, who were saying that they couldn't afford to comply with the constitutional rights upheld in Brown v. Board of Education. And the federal courts did not accept that, it costs too much excuse. And to me, equity in criminal justice is no less important than equity in public education. And so I cannot accept the it costs too much excuse. I will be voting in favor of it, especially as the diversity, equity, and inclusion member of the Board of Governors. So I tried to keep it short, but that's my thoughts on this.
Thank you very much, Tom. We're going to proceed on to Sunitha, followed by Jordan, followed by Brent.
I just want to say that I really appreciate the work of the CPD and the thoughtful formulation of these proposed standards. The issue squarely relates to the administration of justice, and it's absolutely in our wheelhouse to decide this. But I think, and as Governor Ahern mentioned, the issue also relates to other issues: serving the public, championing justice, access to justice, and more importantly, preserving important constitutional rights: the right to counsel, right to a speedy trial, due process. And these are rights that we, as a board, need to safeguard within the context of the administration of justice. I have nothing but respect and admiration for the public defenders who've spoken here today, and for all of them who do such hard work. I started out as a public defender in Canada 30 years ago, and I know how hard the job is. But I just want to say to everyone who spoke, it was very compelling, and to me, you are among the heroes of our profession. I would like to urge my fellow governors to support these standards. With respect to the issue of the expense, we can't afford not to do it. We can't afford to say we can't afford justice. Thank you.
Thank you very much, Sunitha. We're going to proceed on in the following order: Jordan, Brent, Nam, and Francis.
Senator Ahern said a lot of what I was going to say very, very well. I understand the concerns that this is an unfunded mandate, and when you have an unfunded mandate, consequences can be unfortunate because people can try to solve that problem in the wrong ways. But the reality is our Constitution is an unfunded mandate. Justice requires money, and we cannot shy away from demanding justice because we don't know where the money will come from, because we don't know the repercussions of demanding justice. We have to demand justice. And since I haven't heard it yet, I will go ahead and make a motion that we support this proposal.
I second it.
Stand by, everybody.
Oh.
All right, I know everybody's excited. All right, so there is a motion from Jordan to approve the CPD proposal on revised standards for indigent defense and caseload limits found on page 243 and 428. I believe I heard a second as well from Nam.
From Tom.
Wouldn't we be recommending that the Supreme Court adopt the CPD standard, or will be approving?
Good point of clarification. As I see it, the board has four options. The board can vote to approve and send on all or part of the recommendations to the Supreme Court. That's what I understand the motion to be. The board could send it on with no comment. The board could vote it down, in which case the process would end here, or the board could vote to table. My understanding is it's the first option is what has been moved.
That is correct.
That would be my second also.
All right, there's a motion to approve and send on the recommendations of the revised standards for indigent defense to the Supreme Court with a positive recommendation. And there was a second from Nam.
No.
All right. Jordan, anything further?
No, thank you.
All right, thank you, Jordan. We'll move on to Brent.
Thank you, Mr. President. And again, I appreciate all of the comments today, but I'm not so overwhelmingly supportive. And it's because of the downstream that I have questions. You know, if this is adopted and this becomes the standard, to what end? Is this going to be the backbone for the next McCleary style case where the Supreme Court will be issuing a ruling that says that counties and whatever funding authority must comply with their paramount duty to fund this? And, you know, is that what we are willingly stepping into? And again, my hesitation is not about the fact that I don't believe the numbers, though I do question the 6,500 hour that was on the one sheet of an experienced attorney can work cases faster than a first year or second year. Not every case provides unique and novel research. And so I feel as though that is one of the situations where I look at that to say, are they really unethical? And I will also point out that I'm very uncomfortable with the number of people who said that they are violating their rules of ethics, because it's incumbent on every single attorney to say, you know what, sorry, I can't take that assignment. You know, the rules of professional conduct don't allow an associate to hide behind the firm or the partner that assigned a case. I mean, maybe we need to see a revolt on the front line where they say, I'm sorry, I'm beyond what the standards are. I cannot ethically do my job and represent these people. You know, this is troubling, and for so many different reasons that I just want to make sure that we know what we're setting up. I mean, are we setting up a situation where we're going to go and have next year's budget year see a $500 billion or $500 million request from the state legislature, and when they don't fund it,
there's then going to set up this next issue because let's be honest, everything that was said about how the public love to fund law enforcement and police and it's very easy to use crime to motivate a electoral base. It's a lot different to say, hey everybody, let's go ahead and raise our taxes or revenue stream wherever it's going to come from to fund defense attorneys for people who've been accused of crimes. Because outside the legal profession, the wonderful people of the state of Washington don't necessarily differentiate between somebody who's been charged with a crime and someone who's been convicted of a crime. And so that is the part that has not been said. And that's where I really want to know, what is going to be the use of these standards once they're adopted? Are we just really setting up the next, again, I see this as the next McCleary battle, and we all saw how long that took. And some would even argue that though it's been claimed fixed, you talk to many school teachers and they're going to still say that public education is not funded enough. So those are my thoughts and questions.
Thank you very much, Brent. We're going to proceed on to Nam, Francis, Todd, and then Executive Director Nevitt has a comment as well.
Fellow governors, I have 3 reasons why I recommend these standards. The first is that it's fortuitous that we are here at Gonzaga University and we had the opportunity to talk to students. How many of those students would we have recommended that they become public defender if they at all care about work-life balance, if they wanted to start a family, if they wanted to serve their client well and within the adequate standard of they aspire to and what they learned during law school? That's my first reason for voting for this proposal. The second is that recognizing Governor William Ruth, this may lead to a McCleary-like decision by the Supreme Court. But that's a start, because otherwise it's not going to happen. We are giving the tools to advocates like Mr. Jefferson and Mr. Swartz there to go to the legislature and say, we need to fund public defender like we fund public education, because that is in our Constitution. Not just our Constitution, the United States Constitution. And that leads me to my ultimate point for why I'm supporting this, because I am an American. And this is the United States of America, and everybody is supposed to be equal before the law. But my fellow governor, no matter what practice you're in, whether it's civil, whether you're in-house, whether you're a litigator, we all recognize that sometimes, and often all the time, justice is often based on affordability, on who can afford it. And sometimes we know Black people who cannot afford it, simply, and that, I believe, is not what this country is about. Our system, everyone is supposed to be equal. And money is not supposed to be, and how much money you have is not supposed to dictate how much legal rights to liberty and justice you get. That's why I ultimately support this motion.
Thank you very much, Nam. We'll move on to Francis, followed by Todd, Executive Director
I'm willing to
Nevitt,
go
and
last.
Serena.
If Todd and Serena want to go, I will go last. That's okay. You sure? Okay. Thank you, everyone. I believe the spirit of Bill Islop lives on forever. I'm grateful to Nancy for bringing up the fact that Bill Islop, one of the heroes of law practice in Washington, was the chair of CPD when the first standard was passed. And I'm choked with emotion about that, but I'm not going to come to you. I'm not today. Can you hear me now? All right. I'm not going to speak to you today on emotion. I'm going to speak to you as fellow governor that really want the best for our state. I am your liaison to the Council for Public Defense. I sat through all the hearings on this case. I witnessed the vote. I witnessed the vote by the council members Remember, the CPD is a Supreme Court mandated council that is housed within the Washington State Bar Association. Members are nominated by WSBA and appointed by the Supreme Court. As some of the members of the council are prosecutors. In fact, I witnessed 3 of the members are prosecutors, and they all voted for this standard. In fact, one of the votes that were against some of the recommendations were made by public defender. So let's take out the public defender prosecutors divide out of the equation. That is not what this is about. This is about our justice system. Now, the condition that I put before the CPD, and which I rigorously insisted that they abide with, is that they should follow their rules, because this is important issue, an important topic, and an important issues that will raise a lot of concern by communities, by elected leaders, by everyone. And I can assure you at your liaison that they follow the rules of the proceedings governing allowing people to air their views, to vote freely on issues, the same rules which the Board of Governors abide with. So this process, the process that led to this recommendation, cannot be faulted. I can guarantee you that they did not in any way circumvent the process. Now, they have proposed that you send to the Supreme Court this rule, and the motion before us today is that we should do that. Now, I'm going to look at this motion based on the recommendation from our council, our general counsel. Does this recommendation meet the guidelines for us to be able to intervene? And she stated in the risk analysis section of your material that the WSBA standard for indigent defense services are authorized by GR 12.2 and 12.2A and 12.2B and are not prohibited by 12.2C. The current standards were approved by the court, and the court requested that WSBA propose revisions. It is the court that has CPD to review this. The CPD did not wake up and said, we feel like we need to do this. The standard also satisfied the Keller germaneness test by reasonably relating to regulation of the practice of law and to improving the quality of legal services. The board is asked to adopt the revised standard and recommend them to the court. There appears to be little risk in recommending the revisions to the court. There appears to be greater risk in not recommending updated standard for court consideration. The WSBA by statute plays a role in creating guidelines used by counties and cities. Additionally, the WSBA standard can be considered when courts determine ineffective assistance of counsel cases. Failing to maintain and update this standard could impact the justice system and the courts, and could lead to legal and other risks for your Washington State Bar Association. In the equity analysis that also was part of this report, it said the CPD has demonstrated that they have been able to gather input from a diversity of perspectives, including frontline public defenders and staff who see firsthand the impact of the criminal justice system on people from marginalized within their limited capacity, and significant time and attention has been put into the effort. It is evident that client communities reliant on public defense will be most affected by the consequences of this updated standard without comprehensive report. So we have a recommendation before us. The CPD followed the process that the Supreme Court and this board set for them to follow. They proposed these rules, and you can choose and go with this motion, which I agree with, and pass this on to the Supreme Court. You are not the decider. Hello, Board of Governors? You are not the one making the decision on this standard. As much as many of the witnesses of the people that came to talk to us today wanted us to be the decider, we are not. We're not the one to decide this issue. It is the Supreme Court that set the standard for our states. So all we're doing is to look at this. Does the CPD follow the rules? Yes. As your liaison, I said, yes, they did. Does this meet within the risk analysis? Yes, it does. Is this germane to the practice of law? Yes, it does. Now, everyone that has testified today and the letters we got and all the information we got between last night and this morning, all of us as governor received more than over 100 letters and emails from everyone all across the state asking to weigh in. Some like one part, some people like everything, some people like, no, the last part of it, some like the beginning, some like the middle, some like the end, some like none of it. This is how democracy works. Everyone that wrote a letter, everyone that has a stake in this discussion will have an opportunity to be heard. Now, if we as Board of Governors don't feel like that we should sign the letter to support this, I challenge you, let's have an hearing. If we need to say more than send this to the Supreme Court, we can set up a virtual hearing, hear more from everyone again, and then provide a support letter if we want to do that. But for us to stand and stop the CPD from doing the work they have done when they have not broke any rules and any conditions that we set for them, we are not the decider. We are not, we can pretend to be legislators, but we are not legislators. We are just here to ensure that the rules were followed. Did they follow the rules? Yes, they did. And we should pass this on to the Supreme Court. If there is need for us to take a stand and to have a supportive letter, then we definitely, I would agree, we will need more hearing. We will need to be able to have more people come before us and talk about it so that we can argue both sides in our letter. But if what we are doing is saying, CPD, you've done your work, we are moving this on to the Supreme Court, then I support the motion. Thank you.
Thank you very much, Francis. We'll proceed on to Todd, followed by Executive Director Nevitt, followed by Serena, and then Brent, I see your hand is raised online. I don't know if you're wanting to speak again or if that was from before.
It's again. Thank you, President Bell. And I'd like to thank all those who have provided testimony and information about the important issue that we're discussing today. I've been thinking about some of the things that I've been hearing, and I have a few kind of legitimate, real questions or concerns about what it is I've been hearing and how to interpret it and kind of what to do with it. And I appreciate the comments from Treasurer Adewale and Governor Wynn and several of those who have spoken before as well. And I really kind of picked up on something that Governor Williams-Ruth had referenced as well with regards to is there a potential that this could lead to a McCleary type outcome where the Supreme Court is basically driving the legislature to structurally change the funding mechanism for public defense? One of the things I was kind of curious about, I was kind of looking up statistics, and it seems as though there's been at least at the federal level, there's been a relatively significant decline in the number of prosecutions and court cases on criminal cases in the federal courts. It's a little bit unclear to me as to how the state court burden on criminal cases is trending, up or down. However, that notwithstanding, when I look at the apparent repercussion of this proposed amendment to the CPD rules with regards to case loads, it's a couple of questions kind of came to my mind. Is part of this a buildup of cases that is resulted from the pandemic, court closures, or other effects from the pandemic and the limitations on and changes in court procedures with regards to trials, criminal trials specifically? And if that's the case, then would this be a temporary alleviation of the situation, and would there be a temporary or a shorter term potential release that would then kind of resume in normal case loads, and therefore, would there be a potential kind of pig in a python, if you will, from a statistical perspective, where you would have some relief and then you would resume at a lower level of demand or necessity? And so, there's some question as to whether or not, this is, the type of data that we've been receiving is overstated or an outlier due to circumstantial or situational. And I'm kind of looking over to Mr. Schwartz, and so I just, that was kind of something that was a little bit unclear to me. So that was helpful. That does add some additional data point. Another thought that it kind of occurred to me is that, this is a high burnout. Public defense is kind of seems to be a high burnout type of situation. If we think about this, and we look at, I'd like to just kind of look at this realistically. How many folks in the public defender's office were members of the Order of the Coif or Law Review? And I don't know. There may be a lot of, and maybe they're all over the place. But the impression that I get, having gone to law school and having kind of looked for jobs after law school and that kind of thing, is that you really got to be kind of motivated and to go into this situation. But most of the folks in the top of the class want to go to work for the corporate jobs that pay buku bucks, and they don't really want to take the public defender caseloads because it doesn't pay as well. And it makes a lot of sense. The other thing that I've heard is that, and I don't disagree, that 2,100 billable hours is a lot of hours. But if you've worked in any other area of law, that may not be that remarkable. A lot of, I'm sure Serena's probably put it at 2,100 hour a year or close to it or something, right? Big law. Yeah. So there's, so I mean, the fact, things are tough all over, so to speak. As the expression goes. But if you're motivated to do something I get, I served 20 years commissioned service in the United States Navy. So believe me, NAM says, hey, I'm an American. I believe in justice. Believe me, I believe in justice too. I'm highly motivated to do the right thing and to do things that are correct for for the country and for the state specifically, and for the bar and for criminal defendants. So I am not insensitive to this concern. But one of the problems that I see is that we've been looking at this small town and rural for several years. It's become a very highlights the crisis, or well, we say crisis, but the shortage of attorneys and the shortage of not just attorneys, but other staff as well, investigators, the social workers, and other staff. Which the suggestion was that some other non-attorney may take a lot of that kind of pressure off of attorneys as well. So that's kind of another thing. So that's important consideration as well. But when I look at between 1970, I think the United States had about 250,000 lawyers, and now it's like upwards of 1.3 million or something like that. So it's interesting to me that with this growth of number of attorneys, that we're facing a shortage. Now, the statistics are, I think we heard yesterday there was an observation to the effect of the number of attorneys over 60 or 65 is going up, and so therefore we're expecting the numbers to go back down. So, there are certainly some kind of competing trends and some things that are both on both sides there.
Yeah.
But one of the points that I think that either Mr. Schwartz or some of our folks have made this morning is that we're just changing a bogey here, but it's not going to make a damn bit of difference. We're still going to have, and so if you only take 4 cases a year, for example, I think it was Mr.
Todd, I'm going to jump in just really
Yeah,
quickly
yeah,
for a time announcement. So we've rescheduled the 10:30 agenda item. I'm of course willing and able to reschedule our 11:30 agenda item, particularly in light of this. But we do have a 12 o'clock hard stop because we've got an event with the County Bar Association representatives. So just ask all of our governors to be aware of the time. Thanks, Todd.
Sure, thank you. Yeah, but even if we change this, I mean, it won't really change anything except that we'll have, we'll be able to take more time on cases, have a little fewer caseloads, but the number of defendants who need assistance will not change.
Right.
And as Mr. Johnson, testified, this is going to be, incredibly, unworkable from the localities in the state subdivision, political subdivisions perspective because of the funding constraints already. So I think it's a very, very difficult and intractable problem, and I don't really see how much benefit this is going to really have. And the Supreme Court has got the same problem because we're just passing it on to them, and they're ultimately, as Governor Treasurer Adewale did reference, they're the real decision makers. So, but I just the other thing that, but just briefly, I mean, it seems to me as though. Just kind of in closing, it struck me that we never heard the word victims until 10:12, when Mr. Enright finally referenced. And although there are clearly diversity, equity, and inclusion type considerations around public defense, I think that the reference was that almost everybody rates a public defender. And so, but as well, victims of crime, it seems, are disproportionately persons of color as well.
Yeah,
And so
that's true.
those victim considerations are a part of my calculus as well, in thinking about the public, and the effect of public safety.
Yeah.
And so I don't want to ignore those considerations as well. I am probably not going to favor the provisions. I think there should be some changes, but it just doesn't seem to me as though these are really that effective or that, will have that great of an impact on the situation generally. I think, we should do something certainly, but I'm not sure we're here yet. And the other thing, just briefly, the closing, we've had over 100, I think, comments in here in March, but we were originally scheduled for November, and I don't remember seeing 100 visitors and attendees on the November agenda. So I just would close with that.
Certainly had a significant number of attendees. That's true. Let me turn it over just briefly to Chair Schwartz for any
Please.
sort of.
Yep. I'm going to be very brief. Just so that this is a problem. It is not unfixable. It's not untractable. Changing the standards will not make it worse. It will not make it status quo. It will not keep it the same. I'm looking at Dan because he's a prosecutor. I think he knows this. I'm just looking over there. You're right that it won't change potentially filings. Prosecutors will still be allowed to file cases as they want, and defense attorneys and the system that supports it will have to respond to that. Correct. Those are all correct. If we do nothing, I can guarantee you all those public defenders on that list will look at our RPC 1.74A and take up the challenge of the prosecutor who said if they have too many cases that they can't devote to their clients, they should not certify. If that is really what this bar wants that to happen, I will guarantee you that every public defender tomorrow will happily not certify. That will create a crisis like nothing that we have seen in Washington. I do not think that's what we want. That's what happens if we do nothing. Frankly, there's also nothing, that's what happens if we do nothing. To something that Francis said, and this is not gonna sound humble, so please forgive me. But you're in the Navy, my cousin's in the Navy, she served a lot of time on a carrier. If somebody who was building carriers for the Navy came to Congress and said, we are so overworked, our people are making mistakes and ships are going down, would we ignore them? Would we say you're not the expert? Would we ask opposing counsel, maybe the other of our foes military, to comment on what we should do? I don't think we would. I'm asking for the respect for Larry and Bob and the standards committee, which includes prosecutors and judges. This group, as somebody said, are here to address standards. And that's what we're doing. This is not, to your first question, this is not just a response to COVID. COVID, as I mentioned, is part of the qualifications challenge to get people at that higher level. But what I would really emphasize, sorry, I talk with my hands a lot, is Molly Gilbert's statements. Molly is a defense investigator. Since I started practicing, since Francis and Larry started practicing, since Chad started practicing, when I started practicing, Governor, I wrote my notes in hand on a back of a file, and then on subsequent sheets in a file. I did not always have access to a computer. Move forward, and now I have, my wife had a case with 300,000 pages of transcript discovery. Now, if you read 1,000 pages a day, you're a fast reader, that's going to take you almost a year. How many other clients are you going to be addressing in that situation? 0. We are in crisis now. I understand the financial concerns. These are well thought out. These standards were time studies, evaluating following practitioners in 19 states, accumulated and applied in Washington. These are very well thought out by the experts in this state and their foes who are on our CPD and voted for this. It is not an attempt to disrupt the system. It's not an attempt to mess with the system. I'm not trying to make the system not work. I'm telling you the system's not working now. And public defenders and defendants are suffering. I know that the funders are having issues with it. I get it. I am sympathetic. I'm the person who has to ask my county for that money. So I am 100% sympathetic. The reason public defenders choose not to certify, as I think one of the other questions brought up, why do they keep accepting cases? Because they will lose their job. If I tell my boss, I'm my own boss now, but like, if I were to tell my boss, hey, I'm not taking that case, they'd say goodbye. Maybe not in your office, but I have seen it happen. There's a certification process that the justices have put in place when they passed the last standards.
Chair Schwartz, one of the things.
0 attorneys have not certified. 0. And you can't tell me that that's not because there aren't problems. Sorry. Thank you.
That's all right. Thank you. These are very helpful comments. One of the things that's most difficult about this job is actually having to cut people off in the middle of a good point, but appreciate that. So the list I have is Executive Director Nevitt, followed by Serena. And then I believe both Brent and Francis have got their hands raised. Both of you have spoken once already. I want to first give an opportunity for any governor who has not yet spoken, but that's the list that I have, Executive Director Nevitt.
Thank you. As the Executive Director, I don't have a vote, but I do have a perspective that I want to share with you. My comments will be partially substantive and partially procedural. What I find... Are you on mute? Is this better? Okay. What I have found very interesting about this debate is that among the proponents and the opposition, there seems to be substantial agreement. Agreement that there's a crisis in public defense and that the time that the RAND study has demonstrated is needed for a case is completely discordant with our current reality. So I see two questions. The first is, who should bear the burden of that gap? Is it public defenders who work beyond what they're compensated for and compromise their own well-being to serve clients? Is it people accused of crime, or is it our systems? My substantive comment is that it cannot be public defenders and it cannot be defendants. I also want to give voice to some of the comments that are appearing in the chat, which not everyone can see, in response to your comments, Governor Bloom. Many, many public defenders come to the profession with tremendous accolades and accomplishments. And also, I'm not sure that's relevant. We should be invested in the success of every licensed legal professional and justice for every accused person. The second question is whether the standards will help or hurt. And here's my process point. We cannot individually be experts in all of the matters that come before us. So I think our job is to assess the process. Personally, I am persuaded that the Council on Public Defense has done the deep and difficult work of studying the issues, consulting with stakeholders from all over the state. And I take confidence in their recommendation that not only will this help, but it's necessary to garner the resources needed to alleviate the crisis. I have one final process comment. So I think I want to make clear sort of what the ask here is and what the process might be. So it has been clarified, and I just want to make really clear that in the ordinary course, these would be WSBA adopted standards. They're not the Council on Public Defense's standards. So the ordinary course of this would be that we adopt them, we forward them to the court, who may or may not choose to incorporate them into court rule. I do see an option, however, if you declined to adopt them, that you could still send them on to the court and see if the court wants to do something differently. But I just wanted to clarify that the ordinary course would be for WSBA to adopt them as WSBA standards.
All right, thank you very much, Executive Director Nevitt. We will move on to Serena.
Thanks, Matthew. I want to start off my remarks by saying that I think I want to make sure that we're addressing two of the issues that are fundamental to this problem. The first being the idea that our own attorneys in the state lack the ability to do their job to the best of their ability because of their caseload, to the extent that it makes them feel overworked and overburdened and not being able to present themselves at their best. And I think we've all been in that situation before. It's a terrible feeling, particularly when our jobs are client facing and our responsibilities per the RPCs are to our client. The second part of this is that we are failing the service of our public by not having a system in place that allows the people of our public to have, adequate representation with attorneys that have the time to devote to their case. So, I think those are two very fundamental parts of the mission of the bar and are clearly in line with what we should be considering, particularly in light of what's come forth to us today. But to address the issue related to, these excess workloads, in my 19 years of practice, probably the first decade, I was billing 2,200 billable hours a year. And I will tell you, I had no life. I had no work-life balance. It was horrible in terms of the ability to constantly feel like I was doing the best I could do and have a life of my own and have a family and do these things. And I just don't think that that's a sustainable model to recruit lawyers into this profession. We heard very clearly yesterday from the students from Gonzaga Law School who were basically telling us that, they're overworked, they're stressed out, and they're worried about what this profession is going to look like. Now, my argument was going to be, this is setting you up for real life, unfortunately. But that's the unfortunate part about this circumstance, is that we are setting up people for professional lives that don't always, you know, make everybody happy, and they leave the profession over time. And what kind of benefit are we getting by training various different individuals if they're just going to leave the profession over time? So I think about that. But distinctly between my 10 years of practice and what I'm hearing is there's a law firm model towards billing 2,200 billable hours a year, and it's economic. I get paid more by billing 2,200 hours a year in private practice. And it was my decision to do that because it was economically favorable for me to do that, with other benefits along the way. But the point is that this is not the same equation, and this is not the same model. Secondarily, in private practice, when there is a notion that you're drinking from the fire hose, your solution is to advocate to hire more lawyers, who the ability to hire those lawyers is not that difficult given the compensation that's offered as a result of that. So there isn't a dearth of young lawyers who want to go into private practice who are willing to work those hours for an exorbitant compensation. And the ability to flush out that workload actually ends up being economically favorable to those law firms because they're revenue drivers. So I just think that, you know, when you look at this situation from, you know, an equity standpoint, but also from an economic standpoint, it doesn't make long-term sense. And we're doing a disfavor to the public and to our fellow lawyers, and not giving the respect of our profession that it deserves.
All right, thank you very much, Serena. At this time, I've got on the list Brent, followed by Francis. Before going to both of those individuals, I want to find out if any other governors who have not yet spoken have a desire to speak at this time. Looking here in the room, not seeing any. Looking online, not seeing any. Then we'll go to Brent.
Wonderful. So first, I just want to clarify that we are actually the lawmaker in this, that as the motion is pending, these would be adopted as WSBA standards. Can I get a head nod that that is what the motion is and that's what's going to happen? Yes. So respectfully, Treasurer Adewale, your comments were not correct. We are the decision makers. And again, I support everything that's being said, and you know, I really don't give a tinker's tin tea kettle as to whether somebody was a #1 at Harvard or the bottom of their class from the lowest ranked U.S. News and World Report. It doesn't matter. And Justice Gordon McLeod, I thank you for your service as public defender and now on our court. And I really believe that those comments were off base. And again, I don't even care if we are being used as the step into a new McCleary style case. I just don't want to be a pawn unwillingly. And, and I don't know if all the talk about procedure, I'm not in the room, so I don't know where all this discussion about procedure came from, because I have no problems with the procedure and process. So that's not me. I just want to know, because I do not control a county budget, a city budget, or the state budget. So what is going to be the actual impact of these standards? We pass this motion. It becomes WSBA standards, regardless of what the court chooses to do or not do. Because there was the side-by-side chart that we were shown that showed state standard and WSBA standards. Are we then going to be the basis for when insert jurisdiction here fails to comply with those standards, that is going to lead to litigation? I would just like a yes or no, because what good are standards if they have no teeth? I'm always someone that likes to have teeth, and general counsel has trained me for the last 4 years to always say, what's the problem that we're going to fix? And by adopting this standard, is the fix going to be, if a government entity doesn't fund, that's going to now be used as the basis as to why they have to? So that's where my concerns and questions land. Because again, I don't mind being in court. I have no problem. And again, this is a worthy cause. I just want to know, is this what the bigger picture is looking like? Thank you.
Thank you very much, Brent. We'll proceed on to Francis, and I see General Counsel Shankland has her hand raised. Francis.
All right. Thank you. Thank you, President. bro. When I said the decider is the Supreme Court, I mean even the Washington State Bar Association exists at the mercy of the court. If this goes to the Supreme Court and the Supreme Court do not approve it, it is not a whiz-bang standard. It ceases to exist. That's what I meant. Now, the issue, I believe it was Governor Williams-Root that raised the issue about funding. And I want to quote from the packet the statement made by Justice Richard Sanders. Now, I have a lot of disagreement with Justice Richard Sanders. Sometimes I go to my office crying over some of his decisions, but this is something that he said when a similar standard was being put in place, the current standard was being put in place. In 2010, he said, in the state's VANJ case, the judiciary should accept no shortcuts when it comes to discharging its constitutional obligation to appoint effective attorneys to represent indigent criminal defendants. If no such attorney is to be found because adequate funding is not available, then no attorney should be appointed and the case dismissed. It is not up to the judiciary to tax or appropriate funds. These are legislative decisions. That's why I said you're not the decider. It continues. However, it is up to the judiciary to facilitate a fair proceeding with effective appointed counsel if there is to be one. To that decision, I agree with Justice Sanders. Now, my fellow governor, Serena Sayani, said something that is very important. One of our duties as Board of Governors is to attend to the welfare of our members. This year, one of our priorities is well-being of our members. She said that adequately. How can we send people out to practice with mental health problems? I work in an office where, and I've said this openly, where people struggle with mental health. People struggle with keeping families together. I have prosecutors that struggle with this. In fact, I think one of the things that the well-being task force is going to be looking at is the impact of our professions on our lives. And it starts with some of these issues that were raised this morning. So in order to attend to all of this, I believe whether we want to talk about unfunded mandate or not unfunded mandate, that should not play any role in the decision we are making today. And I believe that if we want to call it whiz-bang standard, let it be whiz-bang standard. I vote for the motion.
Thank you very much, Francis. We'll proceed on to General Counsel Shanklin. General Counsel.
Thank you. I'm hoping to just clarify a point, and those of you who are more expert on this than me, you please jump in at some point if I have it wrong. But here is the way I understand it. These are the WSBA standards. If you adopt them, they are the WSBA standards. They do not need to be approved by anyone else. RCW 10.101.030 says that the cities and counties should use the WSBA standards as a guideline, But then you go further, and the court under the RCWs also has the authority to adopt court rules, and pursuant to its rulemaking authority, the court has adopted its own standards. Now, I believe in the presentation, it was made clear that the WSBA standards are more comprehensive, at least at this point, than the court's standards. So I know it's confusing, but there are, as I understand it, two sets of standards, and the court, I believe, will be informed by all of this work and all of the materials and all of the WSBA standards, and may provide, additional instructions to the WSBA about, maybe court rules that they believe or they determine should be amended based on either the WSBA standards or the court's own standards that it might adopt. But I don't think it is accurate to say that the court has to approve the WSBA standards. I believe if you vote today, these are your standards. Now, the court may send them back to you and say, really, is this your final answer? Please consider this, blah, blah, but that is how I understand it. So if I have messed that up, please fix it. Someone who's more familiar with this.
All right. Thank you very much, General Counsel Shankland. A look at the clock. We're 6 minutes away from our hard stop here. Any other discussion, debate, observations regarding the motion that has been made? Not seeing any hands here in the room. Looking online. Not seeing any hands online. One last opportunity. Then we will proceed to a roll call vote. Executive Director Nevitt.
Okay, I'm going to restate the motion. Should I use the other mic? Okay. I'm going to restate the motion and I'm going to take some liberties. So let me know if the mover, if this is not accurate. So the motion is to adopt these as the WSBA standards and send them on to the court. All right, I will proceed with the vote. Francis Adewale.
Aye.
Sunita Angelville.
Aye.
Jordan Couch.
Aye.
Matthew Dresden.
Aye.
Kevin Fay.
Aye.
Tom Ahern.
Yes.
Todd Bloom.
Nay.
Nam Nguyen.
Aye.
Kari Petrasic.
Aye.
Mary Rathbone.
Aye.
Serena Sayani.
Aye.
Christina Larry.
Aye.
Brent Williams-Ruth.
Aye.
And Allison Whitney, are you present? Okay, motion passes 12-1.
All right. Thank you very much, Executive Director Nevitt. I want to take a brief moment to thank the governors, thank the staff, thank the members and the public who came in and spoke today. At least in my memory, this is one of the strongest, most robust discussions and debates that we've had. So I appreciate everybody's involvement. At this time, we're going to go ahead and recess until 1 o'clock. We'll be recessing for our lunch with the county bar representatives. At 1 o'clock, we will come back to have a panel with representatives from our small, medium, and large county bar associations. We'll go off the record this time.